So I'd like to mention item number 12, Your Worship. This contempt petition become infractious.
Infractious?
Yes. It has been complied with.
There's been an order.
Dated 3/11/2025. Passing WPC number 69.
Judgment in order dated
3/11/2025.
passed in WPC number
6985/2020.
being complied with. And under such circumstances, nothing further remains in the apartment. If there is higher conduct.
My name may be recorded, but endorsement. So.
Lordship, I am from Legal Aid Council. There's some inadvertent mistake in the 2 or 3 in the synopsis, my lord, at DAG number 26, line number 4, 26 and 27, that is not 20. By mistakenly, it was 28, typographical error. Kindly be allowed. Let us see what is this Annexure 31 petition. May I start?
Yes.
Okay. Yes. Yes, sir. May I start? So another in the prayer itself. Now you are challenging the order of communication dated. Pardon, my lordship. You are challenging the interim communication dated 31st, Annexure 31. 31, it should be 32. In the page number 28. No, para 28, sorry. Para 28, Annexure 31 shall be 32. What is your case? As per records of rights, that is Jamabandi, for a parcel of land measuring 2/11 Losa, recorded as Pattadar in the name of late Rajanikanta Goswami, father of the petitioner, Sri Pranab Kumar Goswami. In place of late Rukmini Goswami, mother of Rajanikanta Goswami and wife of late Bangshidhar Goswami. As appeared in the copy of Jamabandi dated 4/11/2008, Annexure 1, page 33, and Para 2, page 5-6 of the writ petition. In DAG number 26 and Patta number 43 in Amlapoti village, ward Dibrugarh, owned by the petitioner as per inheritance and jointly with Dibrugarh local board in DAG number 25 And 27 also 20, 25, 26 and 27 also in the same pata number 43. Another copy of Jamabandi dated 19/11/26 also annexed in Annexure 2, page number 34 also reflect the same status of ownership, my lordship, in KP number 43 as stated above. Your lordship, the matter came to the knowledge of the petitioner only in 2019 from the office of the Mojadar, Dibrugarh, after passing away his father, Dibrugarh town Moja, as mentioned in the para 4 in page 6 of the writ petition. The ownership of the above land by late Rajanikanth Goswami,
Have you been paying the land revenue?
yes,
Show me the land.
my lord, up to 26 paid,
Page?
paid in page number
Where's your land revenue?
Rent revenue annexure 10, 11, 12. 12 in page number 45, 46, 47.
Now what is happening?
Now question the ownership of the above land by the Rajanikanth Goswami and late Rukmini Goswami was admitted by the Circle Officer Dibrugarh, East Revenue Circle also, as appeared from the letter dated 0-12-2020, addressed to the ADC Revenue Dibrugarh, annexed in 18A, page number 64 also. So many correspondence are there.
No, now what has happened?
What has happened? I want the, since there is a school and a hospital, two schools and hospitals, I do not want this to be evicted. I want the payment for the compensation of the land only, along with my sister-in-law and my nephew. Because my another brother, Praveen Goswami, has already expired. Only the 3 hairs are there of my late father, Rajanikanth Goswami. That is the humble pair, your lordship.
And why he has approached the legal aid after asking for money?
Because he has approached to the Deputy Commissioner's office as well as the Deputy Commissioner office has forwarded the letter.
No,
to
why is the legal aid council being appointed by Asansa for this matter?
because he is
A person who doesn't have money, it's okay.
yes, he is financially weak.
How can he be financially weak?
He has got some certificate
What is the
and
certificate?
onto the certificate that is there. And after being entitlement, his case was referred to me.
Yes, Mr. Henrik.
As because of the kindly see the annexure 32 page 85. The dispensary was established
1904.
1959 long back. And school was established on the lordship.
But why have you been accepting the revenue? But if there is any truth, first of all, lordship, you see this. Lecture 10, 11.
10, 11 lordship, I have seen since 96, my lord, the revenue has been.
Why these revenue having been accepted means he does have not lost the interest. The power which you can exercise is only when a person loses the interest over the estate, which is 116. He has not, as it appears. Then in that regard, if that land is his, if you are holding into this, you have to pay the compensation.
You take this second.
Issue notice making it returnable on 10th of August 2026. Mr. J. Hendig appears on behalf, accepts notice on behalf of the
1,
respondent
5,
number
6 and 9.
5, 6
And 9.
and 9. S. Sharma accepts notice on behalf of. As all the respondents are duly represented, extra copies of the petition be served upon the respondents. First, the case of the petitioner herein is that the petitioner, along with his sisters
Sister-in-law
and
and his nephew,
his nephew,
Prasir Goswami
are the owners of
And
a
Bina
plot
Goswami.
of land at measuring. What is the size of the land? 2 katha,
2 Katha 11 Losa.
11 lakhs covered by dark number 25, 26, 27. Isn't it?
Mainly 26 and 27, my lord.
Dark
25
number
is a road.
26 and 27.
26 and 28.
26 and 27. It is 20, to be correct. 27. As per Jamabandi also.
Dark number 26 and 27.
Yes, my lord.
Of patta number of
43.
KP patta number 43 of village Amalapati ward, lot number 1 within Moza, Dibrugarh, in the district of Dibrugarh, Assam. It is the case of the petitioner herein is that there is a that upon the said land, the Health and Family Welfare Department have constructed a Dibrugarh State Dispensary. And there is also a Amalapati ME School and Amalapati Girls Primary School. The petitioners have been paying the land revenue over the land, as would be apparent from Annexure 10 and Annexure 11 to the writ petition.
11 and 12 also.
10, 11, and 12 of the writ petition. It is the case of the petitioner that the respondent authorities, without taking into consideration that the petitioner as well as his other relatives have continued to have interest over the said land, have deprived the petitioner the use of and enjoyment of the said land without following the due process, without following the due process. The learned counsel appearing on behalf of the petitioner submits that taking into account that this Dibrugarh State Dispensary, as well as the Amalapati ME School and the Amalapati Girls Primary School have been set up, he would not like to disturb their possession. However, the respondent authorities are required to follow the due process. The petitioner, therefore, it is therefore the case of the petitioner that the said land be acquired by the respondent authorities, and thereupon the petitioner be paid the compensation. This aspect having not been taken into consideration by the respondents, the petitioner had approached this court. The respondents herein are directed to bring on record their stand by filing their affidavits. The district commissioner, Dibrugarh, is directed to file an affidavit specifically on the aspect of the payment of revenue, which is reflected in Annexure 10, 11, and 12. And having received the revenue, whether it can be said that the petitioner as well as his relatives have lost interest over the said lands. The affidavits be filed on or before 6th of August 2006. You develop your case in that line, how I have written.
Yes.
Alright.
What is this?
Lordship is against the GST levied upon the petitioner lordship, which is against the law laid down by the Honorable Court. What has happened, lordship, in this matter? I am the tea broker, and for the tea sold by me, I have paid taxes to the tea garden from whom I have purchased it in the auction. The tea gardens have not paid the tax to the government. So the department has penalized me and levied tax upon me. There is a judgment passed by this Honorable High Court in National Plasto, which held that when the default of the purchaser is there in payment of taxes, the selling dealer should not be penalized.
When is the order passed?
Before that, they challenge the appellate order, appeal was dismissed. Thereafter, lordship say under section 112, appeal lies to the appellate tribunal.
Yes, why?
Lordship, order in original.
Why are you not before the appellate tribunal?
Lordship, clearly against the law laid down by His Honorable Court, Lordship. So only purely question
So
of
then
law.
why did you file an appeal? You have adopted a particular mode going to the statutory appeal.
Lordship.
Who there?
Alternate remedy may not be barred, Lordship, where it is clearly against the findings of this Honorable Court, Lordship.
You can very well
Purely
show this
question of-
judgment before the appellate court.
Purely question of law, Lordship.
No, it is not a question of law. Was the order passed?
The order was passed, Lordship, in 7/2/2025.
Then?
That's the order in original, and order in appeal is on 30/4/26.
So you have time, go and file appeal. Why should
But
we invite
similar
you?
matters, Lordship, have already, this Honorable Court has entertained and passed orders,
So
Lordship.
why should we look into these type of matters?
Recent,
Taking into account that now ITAT is there. And after ITAT, we will see when there is a substantial question of law involved. We'll look into it in the division bench. Isn't it?
Whirlpool Corporation, Lordship,
You appear, why you are
purely against the point of
Dr.
law, Lordship.
Dr. Todi, why you are appearing before the single bench, appear before the division bench? When that GST appeal is there before the division bench on a substantial question, then you get the relief. You can very well get this relief by filing an appeal.
In that case, may I take instruction, Lordship, will come up on the reopening day? Because recently, Lordship, in another case, this Honorable Court on 5/6/26 has disposed of the similar case, Lordship, on the same point of law by observing the judgment passed by the Gauhati High Court in National Plasto Moldings, Lordship.
It will be, if some court has done it, it's a different thing, but why should I do it? Exercise of jurisdiction is a discussion when there is an appellate tribunal, appellate remedy available. I may not like to exercise my discretion in your favor of giving up the appellate remedy.
Then in case Lordship will come up on the reopening date, I'll take instructions.
But Dr. Todi, the learned counsel appearing on behalf of the petitioner, and Mr. S.C. Kyle, the learned and senior counsel, as well as the standing counsel of the DST, CGST. The petitioner herein have essayed the order in original dated 30/4/2000 Order in original dated
7/2/2025.
7 to
2025.
7 to
7/2.
2025. Where is that?
Annexure 3, page 34 Lordship.
Now, there is a rectification order also.
Yes.
That is only arithmetical rectification was done, Lordship.
Have challenged the order dated. Now, 25 to 2025. Finally, see pay annexure 5.
Annexure 5 is order in appeal also.
Understood. What is it written out there? Kindly see the fourth paragraph. Arising out of appeals filed by the appellant as mentioned below against the order in original dated 25 to 2025 passed by Swan. Page 80. Have assailed the order dated.
Lordship.
Order in original dated 25 to 2025.
But
As
Lordship
well as the-
34, it says 7/2/25.
Where?
Page 34 Lordship.
No, page 80.
It is the order in appeal. It refers to.
There it is. We are only concerned with the order in appeal. Are you not against the order in appeal?
I'm against both the orders, Lordship, in original as well as in appeal.
Here, this appeal, that means we have not filed an appeal against that order.
Against the assessment order, I have filed before the appellate authority,
Understood.
Lordship.
But this order is only there, 25 to 2025 is the order which is there in this matter.
The Lordship, the order in original is dated 7/2/2025, Annexure 3, page 34.
But what do you say at page 80? The petitioner herein have assailed the order dated 7 to 2025, which was rectified by an order dated 25 to 2025. And subsequently, the said appellate order in original dated 25 to 2025 was assailed by the petitioner in an appeal filed before the appellate authority under section 107 of the Central Goods and Service Tax Act 2017. The order in appeal by the order in appeal dated 30/4/2026, the said appeal was dismissed. Against that, it is relevant to take note of that section 112 of the Act of 2017 categorically mandates that an appeal lies to the appellate tribunal against an order passed in appeal by the appellate authority. It is also seen that the appeal it is seen that it is also relevant to take note of that the appellate tribunal is functioning. However, instead of filing an appeal, the petitioner has approached this court by invoking the extraordinary jurisdiction under Article 2 to 6 of the Constitution. It is the case of the petitioner that the said appeal, that the issue involved is covered by a judgment of the ordinate bench of the division bench,
division bench,
of the division bench of this court in the case of
National Plasto Molding versus State of Assam,
versus
State of Assam,
the state of Assam reported in
2024, 29 GSTR 544.
so and so. And therefore submits that this court should entertain the instant writ petition. The question arises that when there is an appellate tribunal available, as to whether this court should exercise its extraordinary jurisdiction, that too when there is no inhibition, there is no pre-deposit also. There is no inhibition or any inhibition on the, as per the provisions of law, to apply, to appeal before the appellate tribunal. Dr. Todi submits that he would obtain instructions in this regard. List this matter again on when? 13th? 13th of July 2000.
What?
May I please, Your Lordship? Lordship, the petition was filed regarding the Coach Begila Zamindari estate, wherein the name of the predecessors of the petitioner was recorded as tenant in Khatian number 62, which is annexed in page number 14. Subsequently, according to the Land Holding Act 1974, the petitioner was acquired the status of tenant landholder, despite that the patta was not issued in his favor.
Then
Due to that situation, the apprehension of eviction was
you had the riots.
yes,
Were
Lordship.
you the riots?
Yes, Lordship.
Mr. Counsel, you are there. Same case.
Same case, Lordship.
Now, in that case, it was given to somebody else, that land. And therefore, I passed the status quo order.
Yes.
Here, there is nothing. Mike,
So couple of days back also another same Khatian case was notice was
I know
issued.
that.
Pramanik
That's why I asked you, not him.
Lordship.
Now, here, what is up?
It's the same case, Your Lordship. Only difference is that it is not given to other people. But recently, one survey was done where verbally they were asked to clear the land, and therefore the apprehension of eviction has come, Your Lordship.
Bay of the land.
Lordship. Since patta was not issued yet, despite the 1974 being in operation, so hence the petition, Your Lordship.
Where is your Rayati Khatian? Which one? Put the Rayati Khatian in upside down order. What is this? Huh? Why the certified copy has been given in an upside down manner? Didn't it? Why have you
The
included it in an
vernacular-
upside down manner?
The vernacular language was a bit.
Vernacular is upside, so nobody can read it. Huh? Now, who is this Nur Islam Parmanik? Because the Khatian is given into some Moezuddin Parmanik.
Din Parmanik had co-sharers in the Khatian. And among the co-sharers, the father of The predecessor of Nur Islam Pramanik was also in there, Your Lordship.
Where have you mentioned it?
Page 4, para 4, Your Lordship.
You are the son of Joinal.
Lordship.
Issue notice making it returnable on. When have I fixed those matters? Last time I fixed it on a particular date, no? We have it on the same date, because there are other matters which are there, tagged along on 27th of July, 2026. Ms. Piamonto accepts notice on behalf of the respondent number 1. Mr. So-and-so accepts notice on behalf of the respondent number 20. Extra copies of the writ petition be furnished during the course of the day. It is the case of the petitioner herein that he is the grandson of one Moizuddin Parmanik, who was the Khatyanda of Khatyan number 62. The learned counsel appearing on behalf of the petitioner submitted that Moizuddin Parmanik had 6 sons. And out of the 6 sons, one son, namely one Joinal Parmanik, is dead since deceased. He is the father of the petitioner. The learned counsel further submitted that after the coming into effect of the Assam state acquisition of Jamindari's 1951, the Kuch Begeli, Begila, Jamindari estate vested with the government, and by virtue of section 9 of the said Act of 1951, the petitioner's grandfather became a riot and was issued the final Khatyan. It is the further case of the petitioner that by virtue of section 4(1) of the Assam landholding adoption of relationship under Assam Land and Revenue Regulation 1886 in the acquired permanently settled estate (close) Act 1974. The status of the petitioner, grandfather, became that of a landholder. The said land thereupon ought to have been settled in favor of the petitioner's grandfather, and thereupon grandfather. However, no such steps were carried out. On the other hand, it is the apprehension of a petitioner on account of some survey being carried out by the state authorities that these lands would be that the land under the occupation of the petitioner would be transferred to third parties. It is under such circumstances the present petition has been filed. This court duly takes note of that the issue involved in the instant proceedings is also involved in another writ petition being WPC number 1563/2026, wherein certain interim directions have been passed. Taking into account that there is an apprehension, taking into account the provisions of the Act of 1974 and the apprehension of the petitioner. This court passes an interim direction that till the next date, the respondent authority shall not take any steps to allot the lands of the petitioner and settle the lands under the occupation of the petitioners to any third parties. List accordingly. List accordingly on so and so. List accordingly along with WPC number here. 1563. Mr. Counsel, you have to argue on that day, 27. April.
Will be the law. No, denial of justice to victim by not
What?
denial of justice to victim by not registering the FIR's law before the police authority. 4 FIR has been lodged.
You filed 4 FIRs. To whom?
To different police stations. Since my lord, the police authorities are not interested to.
Huh?
The police authorities are not interested to register the FIRs lodged by the petitioner. Ultimately, the Dibrugarh police has registered the FIR.
And what remains?
But my lord, till it was registered in the year 2024. My lord. Till date, my lord, not the statement of the petitioner recorded by the police.
Why you are not going under 175(3)?
My lord, your lordship kindly pay the FIR lodged before the police station.
What is that?
Page
Page?
18. Man.
Page 18.
Here. Only problem, my lord, when the FIR lodged before the Gauhati police station, the accused was arrested by the police, detained, man. Subsequently, he was released, man, allowed to go, man. Thereafter, the petitioner, out of frustration, went back to his district at Nalbari and went to the Nalbari police station. They told that to file a laws and FIR before the Dibrugarh police. Then when the petitioner approached the Dibrugarh police station, Dibrugarh police registered the FIR. Now my only problem, since it is on record that the police, Sodia police station has detained the case, and if I file an application before the magistrate, concerned magistrate, there is every possibility, my lord, the trial court may direct, my lord, to approach the authority, the magistrate under the Sodia police station. That is the problem, man.
So what? My question is, why are you not going under section 175(3) of the BNS?
Yes.
Why?
That is for that difficulty,
What is the difficulty? That
Since
you have to
my
go to Khodia,
my lord.
go to Dibrugarh, go to any other place where it is required.
My lord, it is,
Gauhati is easier, nearby.
no, my lord.
Then?
Fair trial is a part of my lord, Article 21, my lord.
So what?
Police has denied.
No, no, when there is you see the judgment of Sakira Vasu,
Yes,
that is there. This court
Yes,
is
yes.
not going to do all these things. Right? This court,
despite Sodia police station detained the person, my lord, accused person.
very good. My question is, unless you show me
Yes.
that it is going to under 175(3) would not be a proper exercise of power or exercise of their, that going there would have no
That is
meaning.
my submission, my lord. Since the Sodia police station detained the accused person, subsequently allowed him to go, my lord.
So what? You are not going to the Sodia police station, you are going to the magistrate. You are going to the SDGM court.
If that is so, my lord, the Dibrugarh police, Dibrugarh magistrate at Dibrugarh has no jurisdiction, my lord, to direct the Sodia police station.
Obviously,
My lord.
the Dibrugarh magistrate may say that the jurisdiction lies there.
Yes.
And,
is
if the moment it has gone out there to the Sodia police station, you are then move and 176(3), 175(3)
But
before him.
the FIR is not registered by the Sodia police station.
So what? When there is a direction by which the investigation has been transferred to the Sodia police station, You can very well go within the jurisdiction. Now kindly see 175(1).
Yes,
175(1) says that this court will exercise the jurisdiction over whom the police is there.
yes.
So that very court will be there under 175(3).
But
Go there.
my submission, my lord, the concerned magistrate at Dibrugarh cannot direct, my lord. Your lordship may observe that, my lord, disposing of.
Who are you? You registered the FIR.
Yes, my lord. I am petitioner number 2, my lord. Petitioner number 2 has registered the FIR.
You have registered an FIR.
I have submitted an FIR that was registered by Dibrugarh police.
Then
Initially, the FIR lodged before the Sodia police station on 10/12/2024. Sodia police station on that day detained the accused person. The subsequently accused was released, directing the petitioner to go to the Duliazan police station. Why they have said, I do not know. Then I lodged an FIR before the Duliazan police station. Next day, my Duliazan police station did not do anything, my lord. Thereafter, I, out of frustration, went back to my district, my lord, Nalbari. There I approached the Nalbari police station, Dihu police station. Dihu police station suggested the petitioner number 2 to approach the Dibrugarh police station. Then I again went back to Dibrugarh and lodged an FIR. Then only, my lord, the Dibrugarh police station raised the record.
Then
Thereafter, my lord, although I went to the Dibrugarh police station to record my submission statements in the connection with the case, my lord, police did not do anything, my lord, not even asking for any,
so then did you move the Dibrugarh police station?
my lord.
The magistrate before.
I did not move the court of the learned magistrate.
Why?
Only because the first FIR was lost at Chibu.
So you are filing 3 FIRs.
4 FIR, in fact, my lord.
Why have you filed?
My lord, police is, my lord, directing the,
Police directs out there, they cannot be for registration. There is only 1 FIR now.
my lord,
So that FIR is the main FIR.
my lord.
Others have not been registered.
Yes,
So therefore, against that, you have to go there to the Dibrugarh police station
my lord.
and or the Dibrugarh magistrate.
Although, my lord, 2 years has gone by, my
So
lord.
what? Why should be in the exercise?
Your lordship kindly disposes of directing, my lord, that of making an observation to that.
Regarding, I may only say that I'll dismiss it on the ground that this court is not inclined in view of he has the remedy under 175(3). That is the thing.
That is true. But my submission is that since the accused is from Sodia and police has also detained the Sodia police, my lord. So, my lord, even if I approach the, my lord, Dibrugarh magistrate at Dibrugarh, my lord, that court has no jurisdiction, territorial jurisdiction.
Then why did you file it out there in Dibrugarh? And yes, an FIR can be very well registered. Now the FIR, the moment the police find,
As per direction.
no,
of-
wait, the moment the police finds that the accused is there and the offense was committed within the jurisdiction of Gauhati police station,
Yeah,
then the police is going to transfer it.
it should have been, my lord, but they have to do, they do not do anything, my lord.
Then they don't do anything. Why should this court look into it?
And it is my difficulty, my lord, to approach the planet court of magistrate, my concerned magistrate.
Huh?
Only on that. It is my difficulty, my lord, to approach the learned court, my lord, since that court has no jurisdiction, my lord,
Which
over
court?
the Sodia police station, court of magistrate at Dibrugarh.
Understood. It doesn't have, you made the mistake of filing a FIR wrongly. You
I
can do
do
one
not
thing.
make a mistake, my lord.
You filed it. Who has asked? It's because the Tihu police station, he is legally competent to.
I approach the all
give
concerned
advice
authority.
to file it in
I
Dibrugarh.
approach all concerned police station, my lord.
Not possible. Yes, Mr. PP. Tell me. What has happened? Some offense is committed within Gauhati police station. He goes and files an FIR before the Gauhati police station. Gauhati police station says that no. You go to
They
Duliazan
detain, my
police.
lord. They detain the accused.
No, they detained but did not do register them.
No, my lord.
So say that asked him, then next day the accused was released. Then they went go to
Duliazan.
ask them to go to Duliazan. He files an FIR there. Duliazan police station says we have no jurisdiction. Go back. When he goes back out there to Tihu, he goes to Tihu police station and Tihu police station gives him a legal advice to file an FIR within the Dibrugarh police station. Now the Dibrugarh police station, in respect to an offense which has been committed in Gauhati, registered an FIR. Obviously they can. There's no quarrel with that. The next thing is what do they have to do? They have to then transfer it back to Gauhati. That is the law. So they have to do it. Now question is, investigations are not happening. That is why he has come. Now the problem is, Dibrugarh police station has lodged the FIR, meaning thereby that police station jurisdiction will be in terms of section 175, will be the magistrate over which who exercises jurisdiction over the police station.
It will.
So he has to file a 175(3) there. But approaching 175(3), the problem which Mr. Saike is facing is that Dibrugarh police station has no jurisdiction.
Lordship, that's because the that particular case was transferred to the Lordship, where accidents occurred in the Sodia police station, and which come under the jurisdiction of the judicial magistrate first class team securers.
Of
Team securers.
So there is a subdivision.
so there they have an
Yes,
SDGM.
subdivision.
He has to SDGM, he has to approach one.
He has to move the SDGM. But if it is transferred, you have to move the SDGM out there. That is what I am telling you.
My lord.
You can move it out there because where is the order of transfer?
But
That it has been transferred to them.
no, my lord, there is no such order.
Then these are all verbal.
There is no document, my lord.
Then
My lord. Only
how do you
verbal,
know?
my lord.
You only see an FIR.
Yes,
This FIR is done, has been registered under 173 of the BNS,
Yes.
which corresponds to 154.
yes,
Now it has been registered out there. You go to Dibrugarh.
yes.
You file a 175(3) in Dibrugarh.
If it is not transferred, then he can approach
Yes.
the Dibrugarh.
The Dibrugarh magistrate will think about it. Why should this court think about all these things? 400
Lordship may by observing that, my lord.
Huh?
The lordship may, by observing that, my lord.
regarding.
That submission may be closed.
So you have to ascertain whether that particular case was transferred to the Sodia PS or not.
Not transferred. my lord.
Anyways,
Then he have to 175 to before the.
he is asking everybody to lodge. Look at his prayer. The FIR lodged by the petitioner number 2 on 10/11/2024, 12/11/2024, and 14/1/2024. How can there be 3 FIRs in respect to same week? Okay. Very difficult. It goes against all judgments of the Supreme Court. And who is Nipom Besbu
He is the registered owner, my. He is the registered owner.
of the vehicle?
Yes, he'll. give
What
us-
happened to his vehicle?
My lord, vehicle is not yet been traced, my.
So some vehicle has been lost.
And it is taken on EMI, my.
And why is the other person filing? He's the driver.
To whom, my lord, the vehicle was given on leave.
Now, heard Mr. P.J. Saikya, the counsel appearing on behalf of the petitioner. You appear as PP. PP. No. Okay, Mr. S.S. Croy appears on behalf of the respondent numbers 1 to 6. The present petition has been filed by the petitioner seeking directions upon the respondent number 4, 5, and 6 to provide us to discharge their duties by carrying out an investigation in respect to the 3 FIRs filed by the petitioner in respect to the commission of a crime before the 3 police stations. That is, the Khodia police station, the Duliajan police station, and the Dibrugarh police station. It is relevant to take note of that though the petitioner has claimed that he had submitted a FIR before the Khodia police station, the Duliajan police station, but those FIRs were not registered. However, the FIR which was filed by the petitioner on 14/1/2025 was registered by the Dibrugarh police station. The question arises in the instant proceeding as to whether this court should entertain the present writ petition, taking into account that the petitioner has an alternative and efficacious remedy by filing an application before the magistrate exercising the jurisdiction over the Dibrugarh police station by filing an application under section 175(3) of the BNSS. The law in this regard is clear, is well settled, as would be apparent from the judgment of the Supreme Court in the case of State of West Bengal versus Sakira Basu, reported in 2014.
8 years.
You also got it on that.
8 years.
So and so. And wherein it has been
That may not be applicable.
observed that the writ court under Article 226 should not exercise its jurisdiction inasmuch as an alternative and efficacious remedy is available under section 156(3) of the CRPC, which corresponds to section 175(3) of the BNSS. Taking into account the above, this court is not inclined to entertain the instant writ petition. This court, however, observes that and is not inclined to entertain the writ petition, for which the writ petition stands dismissed. It's needless to observe that before parting with the record, this court, however, observes that the dismissal of the instant writ petition is on the ground of being not entertained. And under such circumstances, it shall not bar the petitioner to approach the concerned magistrate who exercises jurisdiction over the Dibrugarh police station by filing an application under section 175(3) of BNSS.
That is there, but that court has no jurisdiction to direct the Sharia police. That is my view.
They will know what is to be done. They will do.
State of UP. not where-
State of UP.
Yeah. That is my grievance, my lord.
I know that, what you are saying. You said that it has been transferred, but how do I know it? There's nothing. There's nothing on record to show that. You move there, you'll get it from there, it will be transferred, then you know what to do. Part of the project.
Part of the cause.
Go as per Majid.
All right.
Although I have one problem with Mazithia. Mazithia goes on the question of cause of action. Whereas criminal offense is not on the basis of a cause of action, it is on the basis of commission of a crime. There I have some difficulties in but it is after the law laid down, because cause of action is in the context of a civil proceedings, a writ proceeding under 226(2). But can you say, as regards the proceedings under 177, I think 177, old that. 177, can you say it to be a proceedings under 177 to that effect, where the cause of action is on the question of commission of the crime.
Lovely.
Lordship, in this case, Lordship, the petitioner is the brother in respect of 7 vigas of land, Lordship. Out of 7 viga, 4 viga, 17 lessa has been utilized for construction of PWD road without resorting any process, Lordship. I have filed an application before the Deputy Commissioner, Lordship. On the basis of my application, Lordship, a field survey was also done. That which has page 18, Lordship.
When the road was constructed,
Is 2000. Early part of 2023, Lordship.
huh?
2023, Lordship.
Now the road is done.
Road is done, it's complete.
Yes, Mr. Bhuya. PWD. Ask him to take toll. Huh? It is his road. If anybody passing through him, he will take that toll. Something like the Strait of Hormuz. Huh? He's fine with it. Why haven't you paid? Why have you encroached upon his land? Now, anyway, we issue notice to you. Issue notice making it returnable on 19th of August 2026. PR Mohanto, Revenue 1, and for 2, 3, and 4. Number variety, PR Mohanto for 1, 2, 3, and 4, SS Roy, and 5, 6, and 7, Mr. M.C. Bhuya. M. Bhuya appears on the PW. Extra copies of the requisition be furnished to the learned counsels appearing on behalf of the respondents during the course of the day. The case of the petitioners herein. Petitioner herein is that the petitioner is the absolute owner of a plot of land at measuring 7 bighas situated at village Nilaf, Borbom, under CC Borgam, Revenue Circle, Moja CC, in the district of Dhemaji, Assam, which is covered by tag number 463 and included in patta number 64. It is the case of the petitioner that the PWD, Jonai Territorial Road Division, while constructing the road, trespassed into the petitioner's, a part of the petitioner's land at measuring 4 bighas, 17 lechas, and thereupon constructed the said land, a road. No compensation whatsoever have been paid, no acquisition proceedings have been carried out, or any compensation has been paid to the petitioner. In that regard, the petitioner have also submitted a representation to the respondent authorities which have not been considered, for which the petitioner has approached this court by filing the present petition. The respondents herein, more particularly the PWD, as well as the District Commissioner, Dhemaji, are directed to bring on record their stand as to whether the land at measuring 4 bighas, 17 lechas belonging to the petitioner have been encroached by the PWD authorities while constructing the road. And if so, whether steps have been taken for acquisition and compensation have been paid to the petitioner. The said affidavit be filed on or before 12th of August 2026. Yes, Mr. Manan, what is
It's an
next?
application for compensation on behalf of death due to electrocution of the petitioner's daughter.
What happened?
She was electrocuted.
Somebody died.
Yes, the daughter of the petitioner died of electrocution and so she made an
And they have
application for
not paid the 4 lakhs.
compensation of 4 lakhs have not been.
Why haven't you made the chief electoral officer?
That was not made a party. in this.
Why? You
I
should
can-
make them,
Yeah, I have to make it a party.
make
I-
it,
I'll make it. a
because
party.
without
I'll
that,
file
if
an
he is
I-
going to submit the report, then only
Yes.
things will happen.
Yes,
What do-
I'll make a party, file an IA.
You
Bring-
filed,
Yes. No,
Wait.
I have not filed. I'll file.
then we'll issue notice then.
Yes.
Better withdraw and file a fresh one. Make him a party. And then again file memo of parties. All these things are there. Better file a petition, fresh one. It's the same. You have the
Yes.
company.
Yeah.
You only have to mention the,
Yes, he should be made a party.
you have to file
Actually-
one application. It will come up. Then we are.
I understand. It's actually my lapse. I normally don't see all these in the petition. I saw it today in the morning.
Then
In fact, I got the petition in the morning.
withdraw and file a fresh one.
Yes, I'll do.
So the Mr. Y.S. Manan, the learned counsel, appearing on behalf of the petitioner, submits that inadvertently the chief electrical officer, huh?
Inspector. It should be safe electrical inspector.
Inspector of the government of Assam ought to have been made a party for an effective resolution to the present dispute. He submits that instead of, we do one thing, we make him a party. You file a memo of parties. Asking for 4 lakhs, why should we trouble? Issue notice. This is an application filed by the petitioner being aggrieved by the non-payment of the compensation of rupees 4 lakhs. In terms which which one?
Application, you'll also find at page 26.
In terms with,
In terms with your lordship, rule 6 of the regulation 2009.
what is the full name? What is the full name of the regulation? I have to put it.
Yes, yes, I'll give.
There's not a single mention in your petition about that. Very poorly made. So here, somewhere, rules can be opinion. In terms with, this is economic. Somebody died.
Yes, yes, the daughter of the petition. She was 17 years old.
You know anything about the rules? We'll have this as the last item of the day. Wait. In the meantime, get hold of
In
your
that
seat.
case, lordship, I'll withdraw this, I'll file. Why
No,
wait for,
we'll have
just
it
for
as
the
the
rules?
last item of the day.
I'm not waiting for so long. Why should I wait for that? I'm giving the regulation.
Give it.
I'll give it. So lordship may issue the notice, I'll give the regulation.
I will not. You want to withdraw?
Withdraw with your liberty to file.
How can we give a liberty?
By-
It's a
by
formal
making-
defect.
By making.
It's not a
part-
formal defect.
No, I'll make him a party.
We cannot give it. It's the Supreme Court judgment that when it is a case of non-joinder of parties, it is not a formal defect. Supreme Court judgment. We can't give you the liberty, and on the basis that it cannot be decided on the basis, you go to the civil court under Rule 9. You want to withdraw, withdraw.
No, I didn't want to withdraw. I
Don't
was
withdraw.
only with regard to the regulation of
Then I discuss
2019.
it
So that's,
Without the formal party, you can.
I'll give it.
Is your case civil dispute? Heard Mr. Y.S. Manan, the learned counsel, appearing on behalf of the petitioner. Mr. So-and-so appears on behalf of the respondent number 1. And so-and-so appears, you are standing counsel? Okay, none appears on behalf of the respondent number 2, 3, and 4. The present petition has been filed by the petitioner, being aggrieved by the non-consideration of the representation submitted on 14/8/2025 by the managing director of the APDC. It is the case of the petitioner that the petitioner, along with her minor daughter, Himashri Das, was residing as a tenant in the house of the respondent number 5. On 19/5/2024 at around 4:15 p.m. in the evening, when her daughter went to the terrace of the building to bring back the washed clothes hanged for drying, she came in contact with a live wire of high voltage, and due to which half of her body was burnt. Thereafter, the daughter of the petitioner was admitted in GMC for treatment, and on 23/5/2024, the daughter of the informant died due to burn injuries. An FIR was filed on 6/5/2024 regarding the unfortunate incident which led to the death of the petitioner's daughter. The record further reveals that on 14/8/2025, a representation was submitted before the managing director of the APDCL. However, the said representation has not been considered, and as such, the petitioner has approached this court by filing the present petition. This could have duly taken note of Section 63, 67.
Regulation 6, Your Lordship, of AERC compensation to victims electric accidents, Regulation 2019. Regulation 6.
That in terms with Section 67, But in terms of section 181(1), read with section 57(2) and 57(3) of the Electricity Act 2003. The Assam Electricity Regulatory Commission have notified a regulations in the name and style of AERC bracket compensation to victims of electrical accidents bracket close regulations 2019.
It is 5, Your Lordship, 6 and 20.
In terms of chapter 3 of the said regulations, what is the liability payable when a liability arises upon the licensee have been mentioned. Section 6 further stipulates as to what is the quantum of compensation payable for loss of life oblique injury to human or animal is provided in Annexure B, Schedule B.
Schedule B.
In terms of on account of death, on account of loss of human life as a result of electrical accident, it is stipulated in Schedule B that the compensation that can be payable is rupees 4 lakhs. This court further takes note of that there is a manner in which the compensation application is required to be filed, which is section 15. The said compensation application is required to be filed either in person or by post to the chief executive officer of the concerned electrical circle of the licensee or the station head of the generating company public the CPP concerned, who shall cause such claim to be inquired into and determined in accordance with these regulations. It is also mentioned in clause section 15(1) that the claim can also be made to the office of the managing director or any other office of the licensee of the generating company of the CPP. This court further takes note of section 18, which stipulates that a payment of compensation has to be paid to the person entitled within 30 days from the date of the order. And the order is required to be passed in terms with section 16. Section 20 further stipulates as to what is the interest payable. It is relevant to take note of the said section, and the same is reproduced hereunder. From a perusal of the above quoted section, it would be seen that the payment of the compensation has to be made within 120 days from the date of occurrence of the electrical accident. And if the payment is delayed for any reason, beyond 120 days, the compensation shall be paid with additional interest of 12% per annum on the amount from the due date of payment. In the backdrop of the above, it is seen that though the petitioner did not file an application in terms with Form B, but had submitted a representation on 14/8/2025 to the managing director of the APDCL, and the said managing director had duly received the office of the managing director had received the same on 14/8/2025. However, no payment has been made, and it is under such circumstances the petitioner has approached this court. It is very pertinent at this stage also to take note of that in terms with Section 5, the licensee would only make payment if the electrical accident is attributable to the fault of the negligence of the licensee of the generating company of the CPP. On account of not making the chief electrical inspector as a party to the instant proceedings, this court is not in a position to ascertain as to whether the accident, the accident was on account of any attributable fault of the negligence of the licensee. Accordingly, this court therefore disposes of the instant petition, thereby directing the managing director of the APDCL to take note of the representation which was submitted by the petitioner on 14/8/2025. And thereupon, if it is found that the electrical accident was attributable to the managing director, to the APDCL authorities, the compensation be paid to the petitioner. The due compensation be paid to the petitioner. Needless to mention that if there is a delay, needless to mention that in the circumstance it is found that the electrical accident was due to the fault of the licensee of the APDCL, and the delay in making payment of the compensation by operation of Section 21 of the AERC compensation to victims of electrical accidents regulation 2019. The interest would accrue, which the managing director of the APDCL shall duly take note of. Before parting with the record, this court observes that it is unfortunate that in spite of the APDCL having standing counsels and the standing counsels having been served copies, they have chosen not to appear.
I think he is appeared, but she has not mentioned.
You are not a standing counsel. Wait, yes.
My lord, state officer NFLA passed an ex parte ordering me. You're saying that I have enforced the railways law. Now, the inquiry, so-called inquiry they made is before the, my lord, this eviction procedure. And that is unilateral by the railway. I was not a party to it, and the top of the thing, my lord, that service was never completed. We did not receive any sort of notice. My lord, I.
What does
came
the
from-
appellate court hold?
Beg your pardon.
What does the appellate court hold?
Appeared to in the same manner, my lord, they did not go into it. Rather, my lord, your lordship, can we see at page 77, by citing a, my lord, the appeals court decision, to say that in certain cases, the service can be waived. My lord, I am taking to your lordship to that paragraph 11.
No, service cannot be waived, not on that.
Well,
Wait it.
at page 77, paragraph 11. It is to be noted that the instant project of constructing third railway track between so and so is a project of public interest. The Honorable Supreme Court in MC Mehta Chopra case has held that in relation to statutory provision requiring service of notice, distinction is to be made between the case where provision is for individual benefit and where the provision is intended to protect public interest. The Honorable Supreme Court has held in the case of individual interest, issuing of notice can even be waived, but in case of public interest, that same cannot be waived. The Honorable Supreme Court observed that in case of involving individual benefit, now the fact of the case is quite different here. My lord, I am having a patta land, and the tag number is 233 in my case. And the software, the railway, they are claiming their tag number is 21. So therefore, my lord, there is heavy difference between the two cases. Apart from that, my lord, if your lordship kindly see at page 81.
Did you give evidence?
My lord, they did not take evidence, my lord. We have,
In appeal, why didn't you say that you are going to use evidence?
if your lordship look at page 81, the court draws the inference on para 17 law. From the above, it can be inferred that the appellant is an unauthorized occupant of the public premises, that is railway plot number so and so. Now, if I take your lordship to the notice, I mean at page, your lordship will see the address given there. At page 49. I don't stay there in that address. My address is at Varlamuk, my lord. In the cost title, your lordship will find what is my address. And my business
Are
address.
you referring to this order at page 49?
Yes,
49.
yes. This is the order we said.
Here you say accordingly, the petitioner railway has filed the petition and submission along with the corrected amended doc number so and so.
Yes.
A notice was issued, according a notice under section A was issued on 10/5 from this court, the opposite party with corrected amended schedule of land in question in which the opposite was advised to attend so and so. The instant eviction case was refixed on so and so for hearing. So and so had opposite is absent hearings on today. The case is being proceeded as party on here. Previously, a notice on the same was issued to the school court why in order of eviction should not be passed against him for the same notice was received by the office party Suren in absence in the presence of Suren. Also a notice on the section 8 issued from this court on the email to the opposite party with corrected amended details to receive of this so-called notice the opposite party neither turned up again. So you have received the so-called.
No, my lord, these notice was never served us. My lord, we explained
Ask
before the
how
appellate.
many petitioners are here?
Two petitioners, my lord. One petition number one is, my lord, we are appearing, but then so far two is concerned, they did not include us as a party. So far petition number two is concerned, they did not include.
Why are
as
you
a party.
filing one petition for both? One
No.
has a different cause of action, the other has a different cause of action.
No, my lord, the same plot of land.
Maybe, but other has a different right from petition number one. Petition number one has been served, the notice is what is mentioned out there.
So far petition number 1 is concerned, they never served a copy. My lord, we have explained it.
No, it has been mentioned in this order.
It's not correct at all, my lord.
Then,
My lord, the
did
notice was served to
did the first appellate court?
that first appellate court also.
No, no, that is okay, but what does he say about the notice of you?
My lord, your lordship kindly see what first appellate court has said. It's okay, Ram, my lord.
Only see at page 76,
76, yes, para 9, my lord.
above 9. 4 lines above para 9.
Yes. My lord, your lordship will find
Records
record reflects that thereafter the said prayer was allowed and the learned state of
The
seven.
records reflects that the said notice was received by the appellant, his representative on 16/7/2025.
That
And
representative,
thereafter, as the appellant did not contest the area, the matter proceeded ex parte and order was passed.
my lord, that representative happens to be one of the staff of my tenant. Now he gave it to
Who is
us.
your
on-
tenant?
My lord, my tenant is one Gautam De. We have stated in the appellate, before the appellate court. And he, my lord, gave that notice to the petitioner on 28/8. Thereafter, we filed an application before the state officer. We wanted to file the stockers, he did not receive it. Saying that after passing the judgment, I cannot take it. Thereafter, we filed this appeal.
And you challenged the order of 31/7/2025,
Yes.
which was served upon the representative of Gautam De.
You know, we gave this to the petitioner number 1. And after coming to know about that, we filed an application before the state officer. Now, he did not accept, received it, saying that I have already.
No,
filed
if that person have received it and you accept it, then how are you later on?
No, I came to know from that person only that ex parte order was passed. Then I came before the appellate forum. And then your lordship kindly said, para 9. Is the case of the appellant that the notice which were allegedly issued by the learned state officer were not served upon the appellant. The appellant claimed that the notice were issued, the address is mentioned in the said notice. Your lordship will find in that said notice, the address is rarely plot number so and so. This is not my residential address or my business address. The appellant submitted that the residential address of the appellant as well as the business address of the appellant is not the same. It is further submitted that in the property which was purchased by the appellant along with his sister, they have constructed a three-story building, and one of the portion of the building is rented to one Gautam De. It is further submitted.
No, you should have gone and in that appeal, you should have given the evidence. Why haven't you given evidence?
Well, Lord, they have just ordered and for hearing the matter, the court will say, I will pass the judgment. And your lordship has seen how the
No, you
judgment.
see, the appeal was filed, no, obviously, the appeal was filed in 2025. Judgment came only on 7, arguments were heard on 5/3/2026. Judgment pronounced on 7/4/2026. So why didn't you file an application to adduce the evidence of the officer? Because you see, if it is the land of the government, you have no business. But
No,
if you
it is
say
the
that
land
this
of the
is your
government,
patta
correct.
land, no, Mr. Kunsal, if you say this to be your patta land, obviously you ought to have adduced the evidence of some, the revenue authorities to the effect that this is your patta land. Why didn't you do that?
No, my lord, it is the duty on the part of the
You-
appellate forum also, my lord, to go for an independent inquiry.
No,
The revenue authority.
absolutely no. It is your duty. You are coming out here to making an averment to the effect that you are the owner of this patta land.
Yes.
A patta has been issued to you. This is the land which you have purchased. This is your averment.
Your
They are
lordship, right.
categorically saying that this is railway land, this is the cadastral map, and this is the land which is being seen out there to the effect that this falls out here. It is your duty to come up before the authority, the appellate authority to show. Now, how will this court, without that evidence, look into this aspect? Tell me.
Lord, that case, Lord, can your lordship give us a chance so that we can avail that? And then we prayed for local inspection also, that was not allowed.
Did you file that application?
No, at the time of argument, we made
No,
it clear.
again,
But anyway, my lord,
this
those
is
are,
not done.
yes,
It
those
was very
things,
unfortunate, very poorly conducted. Kindly come to paragraph 16, Mr. Gogoi.
paragraph 16.
1-6.
Really.
How could the court come to a conclusion without that evidence being taken?
The basis of their documents, paragraph 13 was. Paragraph 13 was, there is a boundary of the service was.
Now, understood.
Then,
I'm not on that. The case of the appellant is that he has purchased this 1 katha of land of so and so. The appellant has enclosed a copy of the sale deed along with the memo of the fee. If we carefully analyze the schedule of the sale deed relied upon by the appellant reflects the boundary has been enumerated as not land of Ram Shankar so and so Sushil Bay and Shobha Devi Patwari and south land of so and so, land of Nogania. Now who is the appellant? Sushil Bay. And he has land on the north.
Yes.
How?
My lord, I'll take your lordship to that. We have, and I have the send it, my lord.
page 50 my lord. Page 50 my lord, we can come to the lordship schedule. Schedule is not a railway track lordship. Yes. South is private land and government land lordship. It is typically defined lordship. That details which are produced before the court. The court, the schedule is lordship in the prediction notice.
Okay.
Get the
Now,
basis of-
no, therefore, who could have ascertained?
Is on the basis of the materials which is placed by the lordship.
Understood. He said that this is his land. Let us appreciate that it is his land. And if he has a sale deed, he must be having a Jamabandi also. I hope you,
We have an next
where is it?
at page, my lord, 36.
Where is your name?
My name your lordship will find in extreme right, my lord,
That one, number 3 and
land measuring
number 3 and
page,
4.
page 36,
How much is your land?
one katha 5 lakhs. Land measuring so and so, social by and Srimati Shobha Devi Patwari.
As per the order dated in this patta, in the place of Bhaskaram Bolwa, the following names are recorded. In 1.34 R. 1.34 R will be 134 square meters.
Because in the railway, one subject railway station is the land also, but we open the railway line. That's why it's down.
No, whatever may be, my question is, the only way to find out, he should have given evidence.
Even with the others also, there are objections also there also. Regarding present form, this picture is not reasonable. Then we kindly come to the cost calculation before discussion. So in application under lordship 227 of the Constitution of India laws, we rely minor third laws. The present form WBC is not matter.
Right there. Last day of the day,
Last year the there was
227, this should have
On
been
the-
clear.
On the last occasion, my lord, when it came, my learned friend say 226 is not
226
maintainable.
Not maintainable lordship.
Now today is saying
Yes.
227 is not maintainable.
Not
No,
maintainable.
he said, no. Mr. Doctor, that is what he is not saying. He said that it is a petition under 27 and as such should have come as a CRP.
CRP laws.
That is, my lord.
In fact, he is not saying anything against you. He is saying that this court should not exercise jurisdiction.
My lord, then it can be converted to civil division petition. my lord.
When lawsuit Roscoe will be defined laws. I have no objection taking the matter minor. I have no
Should we be so
I have no
technical? my lord?
objection. It is not a thing. It is the lawsuit procedure written the Gauhati High Court rules.
As per the law laid down by my lord itself also. No, I understand all that. I understand all that, but your lordship can.
That's okay. That I know how to exercise. Don't know. I'm not. My question is, you see, there is an urgency. We do one thing. There are two ways now.
Yeah, I will. On the basis of the material worship, just before the Bible, there is no any jurisdictional error also, there is no perversity also. There is no any worship, manifest worship. The thing is that there is no any arbitrary action also taken. It's not beyond that exercise is jurisdiction.
No, understood. No, the problem lies here. It is the revenue authority who has to say as to where his land is. He should have done that. I'm not saying that it is not. It is. He should have therefore gone for this evidence. Now, the First Appellate Court exercises the jurisdiction in such a manner, and more particularly at paragraph number 15, where he sees on the basis of the records and does it. Now, was it proper on his part to decide only on the basis of this without calling for a local inspection from the revenue authority as to whether his land, which is, there is no quarrel that he has a plot of land of 134 square meters, but whether his land is this land or he has encroached upon the land of the railways. That aspect could have been done on the basis of a local commission. A commission could have been appointed and the commissioner could have looked into that very aspect when it is more particularly a question of boundary. So the Supreme Court has been always saying, even in a second appeal, when we take it up, it is a question of law, substantial question of law as to whether when it is a question of boundary, then it is the duty of the court also to ascertain it by way of a commission.
Was also honorable Supreme Court said that boundaries with the escort are also need of title deed.
Understood. There's no quarrel that he has a deed, you also have a deed, there's no quarrel. But who knows as to whether this is this on face of it when it is seen. The court doesn't look into it. The court works on the basis of some report. Now the commission's report will form the basis of the evidence, thereby saying that no, his land is outside. This particular dark number is outside and this land is this one. That was the commission which should have done it and proceeded with.
Then was it the petition, whether was it related. Yes, not I would get part also, yes, not when when petition also not there was. Then what is land is not annexed here. I have the plain was. This land is not annexed with this petition. I bring the plain was. This is not their case was. They basically on the basis of that particular something, nothing is there. The single argument is there. I bring the claim also. They have not annexed it also.
No, they have not done it, but the fact remains when you are exercising the jurisdiction, you have to exercise the jurisdiction in a fair manner.
Yeah, on the basis of the railway place.
Definitely, there is quarrel. There is no quarrel with the fact that you have to do it.
That particular province is national important. This is 4-line extension of the electrification partners. Only that portion we have 6 partners. It's not a case that was it is there and something is not going there. It's not a case.
There can be. I should notice out here and thereby direct the revenue of the circle officer to carry out the A and submit a report. And on the basis of that finish. That is one. But this, I don't know whether at a later point of time, this matter would come back to me. I don't know. The second is, I remanded matter back to the First Appellate Court only to decide by issuing of a commission only to the effect as to whether these dark number and the cadastral map here on the basis of issuance of a commission and commission within a period of 3 months. This is the 3. That will be much better. With that, what will happen is you have now a concrete base. if there is an interference by that, if there is anything to that effect, yes, then you can very well tweak him. Then your entire proceedings is being taken. I think these are the two.
That approach is the best approach. Otherwise, those who have proper procedure, in 27 application, according to the years, it was submitted before the first appeal. First appeal was never done before the beyond the jurisdiction. There is
No, Mr. Kumar, that is what I'm saying. We are not understanding the basic aspect to the fact that when there is a dispute as regards the boundary, the court could not have done it without the requirement of a local commission. That is the most pertinent thing. Has to be done. Yes, if it is a case, in a case, normally what we get these type of cases. The cases what we find out here is he is claiming the government land or somebody is claiming the railway land. This is the mostly you get this type of cases. But in a case of this nature, the necessary requirement is for issuance of a commission. To the effect as to find out as to whether this land is this or not. And after that, the court could pass an order. And keeping the matter pending, because only thing is, if I keep the matter pending, okay, it will only get delayed.
also corporation, I have no objection. I have no objection that part. Otherwise, lawsuit is just immediate lawsuit. It is not a proper form of commission. Otherwise, we just critical decision to start process. We have to find a clear. That part, my learning, lawsuit.
It is a wrongful registration by the office.
It is not a wrongful registration, was it?
You kindly see the
It's a
rules.
lawsuit.
No, kindly see the rules categorically say
Categorically says
that when it is an application under 227, it should be registered as CRPIO. Now, isn't it the mistake of the office?
But that's why I am saying that lawsuit. That's why I am saying that my lord may just immediate lawsuit. It should be lawsuit civil involvement. Otherwise, lawsuit in other cases also. So many cases will come lawsuit. We will face something. Because railways file, I have filed more than 30 cases civil involvement. We are not going to support. That can be converted.
That
cannot make a precedent. Conversion also I have no objection. If my lord take as a WBC, that also I have no objection. Just I indicate that, my lord may just indicate that part. As per lordship's observation.
He is saying so much on that.
No, it is the necessary point. It's required to sustain. Paragraph 9 of lordship's act.
No, this is based upon that Supreme
Supreme
Court
Court
judgment. No, here he files at 227. He doesn't say it's 227.
That's why I am saying that lordship, the nomenclature should be civil involvement.
No, it was also made as CRP.
But that is why it is made as CRP, but paragraph 9 very specific lordship.
Look, paragraph 9 is on solemnicity.
Submission, lordship quoted 9B lordship.
I think we interfere with the order. Direct them without touching only on thing and direct them to disposal of putting things.
So I am not thinking of.
I think that is a better option than to keep this matter pending.
That's lordship.
And you appear, both of the parties, we direct them to appear on 15th of July before, 15th of July before the court. And the court will issue a commission. But that commission will take some time, na? But should I issue the commission from here? If I issue a commission, it will be fast. What do you say?
Yes.
Because there they will issue and they,
Then
the
process
district,
will be-
they will do it at their own way. Or we can do one thing. Issue notice. Direct them to issue a commission, direct the circle officer to submit a. And on thereupon we send back. Then in that regard, it would be much better. So that on that basis, let the appellate court decide.
What's the question? When we will first start?
Fast.
Within a time frame. Within a time frame, that part will come.
That they will do it. First, my question is only that if I get that, because with me, when we pass an order, the commission, the circle officer will be moved from.
It will be proposed, otherwise also the project will be.
Obvious, this is the biggest. I think that is a better. issue notice making it returnable on, is the central government a party? No. State government? No. There's a problem. You do it after some time. You wait for some time. You come over from there. Because there again, a problem is that the circle officer is not a party now. How do I get that? No, you do it. I have other matters. I have only 20 matters. Let me finish here. You come. Let me also think in the meantime. Yes.
Lordship, I am appearing in item number 8. Actually, I would have come personally. Actually, I'm suffering with the back pain. That's why I'm seeking this video conferencing. Lordship, issue here is basically the matter arising out of a drugs and cosmetic set and the medical device rules. The simple issue here, the medical device rule provide for appointment and designation of the laboratories for the testing of various medical devices. And for the item which is in the question is the catheter. For that, Gauhati Regional Testing Drug Testing Laboratory is not the designated laboratory to test the sample and issue report. So in the present proceeding, what happened? The test report is issued by the Gauhati RLDT, and on the basis of which the proceedings are initiated by the drug inspector. So issue here is purely legal issue, whether the test report, which is issued by the government analyst, RDTL Guwahati, is valid or not. For that, Lordship, kindly have a report on page number 57. Or before that, Lordship, I will just give the brief of the case. Kindly have page number.
You're challenging the report dated 4/2/2026.
Yes, Lordship.
Why?
Because it is without jurisdiction. Without jurisdiction. What in the scheme of the Act, Lordship, the government of India, central government, has appointed laboratories for the purpose of
Where's
testing.
the report? Where's the report?
Page number 57, Lordship.
Two?
Page number 57.
57.
57, 57.
57. Report of the test or evaluation of medical devices by the medical device testing officer. What does it say? Are evaluated on the conditions of the scene of. What is the report?
Report
Samples do not
says
comply with IP 22 with the bacterial.
respect to bacterial. Yes.
Matter ends. Now, why do you say that he doesn't have the jurisdiction?
Yes, Lordship. Kindly see the page number 113. And then I will proceed through the rules and act also.
Yes.
So this is Lordship order. This is a government family welfare. In pursuit of the power conferred under Rule 2, Sub-Rule 19, the medical device rules, central government hereby designate the laboratory specified in clause 2 of the table below, facility for carrying out the test and evaluation of a medical devices as central medical device testing laboratory. And Lordship, kindly see phone number item, Guwahati. So Guwahati has been authorized or appointed only for the purpose of disposable hypodermic syringes, disposable hypodermic needle, disposable perfusion set, and IV cannula. Mine is a catheter. So if we go further, which is the laboratory, then Lordship just 115, just 2 pages later.
So this is of 2018.
Yes, Lordship.
So your basic case is in view of this order of the central government,
Yes, Lordship.
the medical officer on his own cannot, or the regional drug testing laboratory Guwahati cannot do this.
Right, Lordship.
That's your case.
Yes. And Lordship, 115 is my answer.
Huh?
115 is also my answer. Page number 115. Kindly have that.
What is this?
This is basically 22 order and 6 number the regional testing laboratory Chandigarh. The
This is in
Chandigarh,
addition to that.
yes.
after item 5, so this is an amendment thereby
No,
bringing
this is
the
a
regional
earlier,
drugs
earlier.
testing laboratory Chandigarh.
No, not sure what happened. This rule, 2017 rule, come into 2017. So the government taken a one after one various items for the purpose of designating the laboratory. So in first item, this 113, some items were notified who are the laboratory they can test. So in this case, the catheter was taken later on. Catheter was not in 2018 laboratory authorization.
Your catheter,
Yes, my catheter
siliconized, and it is being done by whom?
by the Gauhati.
No.
It is
The catheter is given to the regional drugs testing laboratory
Chandigarh.
Chandigarh,
Yes, Lordship.
and it is
115.
not available to these persons out there in 2018.
Yes,
There's no,
Lordship.
these, huh?
Only this kind of samples were being expected by the drug inspector.
Huh?
Person who collect this.
Use the mic.
May I please, my lord?
Yeah.
Am I audible now?
Yes.
These kind of samples were being extracted by the drugs inspector, and he is authorized under section 21 of the Drugs and Cosmetics Act. After obtaining the sample, he made 4 samples thereof and sent to the regional drugs testing laboratory. The moment regional drugs testing laboratory find that a particular product or a sample is not of standard quality, then a particular show cause notice has been issued to the manufacturer. Thereafter, manufacturer is having an option of appeal, and maybe under section 25(3) or 4, then he was given 28 days time, my lord, to challenge it. Either he made a request to the drugs officer, or he can also make an application to the CGM that he want to send that particular sample to the Central Drugs Laboratory, Chandigarh. That option is provided under the statute. Now the question is, whenever RTDL examine and hold a particular report that a particular sample is not of standard quality, then, my lord, if the manufacturer did not prefer to challenge it before the CDL Chandigarh, then the report that has been submitted by the Central Drugs Laboratory attains its finality. It becomes an evidence of a conclusive nature.
Finding of whose?
Finding of regional dust testing laboratory. Guwahati.
That will attain finally.
That will attain fatality, provided they prefer to challenge under
Now,
section 25(4).
This catheter will come within the ambit of drugs.
That I'm not sure, my lord.
Then
Yes,
how are you
Lordship, yes.
making the? I understand that for a particular aspect as regards the drug, it is okay.
Yes.
Now let us see the medical. What is this act? Medical.
Lordship, I will explain. I will explain the particular point. Exact point has been taken by Section 3(b) of a Drug and Cosmetics Act that says any devices that is declared to be a drug will be considered as a medical device. So for that purpose, Government of India has bring this medical device rule 2017, whereby all the items which is go into treatment, mitigation or diagnosis of the drug of disease is declared to be a medical device. So as per section 3, if any item, section 3,
All medicines for so and so human or animal for human diagnostic.
section 3(b)
Intended
Clause
to be
4.
used for in diagnosis so and so. What's device? Okay, so in view of section 3(4),
Yes, Lordship.
it would become a drug,
Yes, Lordship.
3(b)(4).
Yes, Lordship.
Now, if it is a 3(b)(4), then that is what he is saying. When an
Now, Lordship,
inspection is
I
being
will
carried out
request-
under section,
Yes, Lordship, I will just request for that. Kindly see section 20. I will give reply. Section 20.
20, yes.
Yes. So section 20, provides for the government analyst. So it says the second part. One is it is central government. Basically, the central government may also by notification the official gazette appoint such person as it think fit, having the prescribed qualification to be government analyst in respect of such drugs or class of drugs or such cosmetic or class of cosmetic as may be specified. So the appointment of the government analyst has to be for the class of a drug and not on the region basis. So my point is here, the government analyst by the notification
Medical, where is the medical device rules?
rules. Yes, Lordship. Kindly have Rule 19, Lordship.
This is different. Medical device rules. You are on 25-4. Mr.
He,
Commissioner,
Lordship, I will explain that
you are on
also.
25-4. So
Yes.
thereby, there's an opportunity for the purpose of challenging that.
Challenging.
Unless the sample has been tested or analyzed in the central drug laboratory where a person has been under subsequent notified his intention of using evidence in contravention of the demand, the court may of its own motion or in its discretion make so and so. And this has been held to be a valuable right.
Valuable, right.
Now, why he has not, now this report which is being given,
Yes, ma'am.
have you placed it in any proceedings? You have issued a show cause.
My lord, we have issued a show cause, but this particular writ petition does not reveal that any criminal proceeding is instituted against the writ petitioner till now. So how and in what manner they are being agreed? That is my humble submission before this honorable.
No, you have issued a show cause.
No, statutorily, I have to issue the show cause. We do not have any option. The
You are
moment,
issuing the show cause under what provision?
maybe under section 25(3) or 4. Right now, I do not have the act.
22, Section 22, Lordship.
Say
22.
under section 22, I am sorry. My lord.
Section 22.
Section 20.
Yes, Lordship. That gives the power of a drug inspector.
But I have received a copy of writ petition little lately, my lord. That is why.
This is a residue power, Lordship, in Section 22C, 22C.
Okay, we do one thing. We issue notice,
Yes, my lord.
you file your reply. Issue notice making it returnable on 17th of August 2026. Mr. So-and-so accepts notice on behalf of the respondent number 1 and 2. 1 and 2.
Yes.
1 and 2, na?
Yes. One and two.
Extra copies of the writ petition be furnished to him during the course of the day. The petitioner herein, which is a company incorporated under the provisions of the Companies Act 1956, is in the business of surgical disposable products and duly holds valid manufacturing licenses under the Medical Devices Rules 2017. It is the case of the petitioner that the petitioner in the present proceedings have assailed the report dated 4/2/2026 given by the medical device testing officer of the regional drug testing laboratory, Gauhati, in respect to the petitioner's product, namely silky gold foley balloon catheter, bracket siliconized, bracket close, Rebel sterilite, page 57 of Mr. S. Mohapatra, the learned counsel appearing on behalf of the petitioner, submitted drawing reference to the order dated 1/6/2018 issued by the Ministry of Health and Family Welfare, stating inter alia that these medical devices can only be tested by the laboratories which have been mentioned, which have been notified by the central government in terms with Rule 19.2 of the Medical Device Rules 2017. The learned counsel further, referring to the notification dated 28/9/2022, further submitted that in respect to catheters, the central government had, by the notification dated 28/9/2022, notified that it is only the regional drugs testing laboratory Chandigarh who has the authority to carry out test and evaluation of the said devices. It is therefore the specific case of the petitioner that the report dated 4/2/2026 was given by a laboratory which is not authorized in terms with Rule 19.2 of the Medical Devices Rules 2017, and as such, the said report cannot be acted upon. Per contra, Mr. B. Dekar, the learned counsel appearing on behalf of the petitioner, a respondent, submits that in terms with Section 3B(4), Roman 4 of the Drugs and Cosmetics Act 1940, the catheter would be a drug, and as such, in pursuance to Section 25 of the Drugs and Cosmetics Act 1940, the petitioner, if can very well challenge the said report by requesting that the report, the analysis be carried out, the evaluation and analysis be carried out by the Regional Drugs Testing Laboratory, Chandigarh.
Central Drugs Laboratory, Chandigarh.
No, here it is the Regional Drugs
Completely of that.
Chandigarh. And instead of making such a request, the petitioner has approached this court by filing the writ petition under Article 226 of the Constitution. First, it is the opinion of this court that the aspect which have been, the report which have been challenged is on the basis of, is questioning the jurisdiction as to whether the Regional Drugs Testing Laboratory Gauhati would have the jurisdiction to carry out the test in terms with Rule 19.2 of the Medical Devices Rules 2017. And as the question of jurisdiction has been raised, that too on an interpretation to Rule 19.2 of the rules of 2017, this court prima facie is of the opinion that this court can entertain the instant writ petition. Accordingly, the respondents herein are directed to bring on record their stand by filing the affidavit next to 17.
Huh?
17. by filing the affidavits on or before 5th of August 2026. Petitioner granted the liberty to file reply on or before 14th of August 2026. So, taking into account that the petitioner had approached this court after 4 months, without granting an opportunity to the respondents to submit their reply, it would not be proper on the part of this court to pass any interim directions. The said interim directions shall be considered on the next day.
Lordship.
What is this?
Lordship, this is a case related to attachment of my bank account. Page number,
When did it happen?
page number 14. Last year. 2025. Page number 14 is an order related to an arbitration proceeding. The case has been disposed between LLT Finance and Earth Rural Connect Services. I am one of the directors of Earth Rural Connect Services. During the pendency of this case, an interim order was passed dated 23/5/25, wherein my bank account had been attached. As per this order, the arbitration proceedings has been disposed and a direction has been given to the respondent to remove the attachment of my bank.
Why are you here?
Why I am here, Lordship? Because I am one of the directors of this, and due to some financial,
No. This is on the basis of an order passed by the arbitrator.
yes,
You are a party.
no,
Are you a director of
No, no.
Art Rural?
I am one of the directors of
So,
Arthur.
Whose account has been free?
My,
So very well. Go there before the arbitrator and say, why are you here?
Lordship, in Annexure 3 and 4, both the parties of the who were parties in the arbitral proceedings both have
This
said
is against an interim order.
the writ petition related to
The joint application has been filed by the claimant and respondent on getting recorded the terms of compromise between them and passing consent. Further, in view of the so and so under section 17, we had disposed as withdrawn. And needless to say that the interim order dated so and so the manager so and so having is directed to remove the attachment put on the bank account of Antanu Patwari in the matter dated so and so, bearing number if attached in furtherance of the order dated email. Now what has happened?
after this order, the bank has not followed this, and both the parties of this arbitration proceeding, in page number 15 and 16, they sent letter to the concerned branch manager to remove the attachment, but still date no action has been taken.
Issue notice making it returnable on. Why are you making the LNT and all?
LNT, because he's also a party, and I am not a member of LNT. He's the opposing party to in the arbitral proceeding.
Issue notice making it returnable on 3rd of August. So the petitioner is directed to effect service upon the respondent numbers 1 to 7 by speed post. The said steps are required to be taken within 3 days. The case of the petitioner herein is the respondent that in pursuance to an order passed by the arbitral tribunal on 23/5/2025, the petitioner's bank account was frozen. However, on account of 23/5/2025 by the learned in the arbitral proceedings number LNT/AR/LOT-5/45, the petitioner's bank account was frozen. However, pursuant to a compromise and a consent award being passed on 30/7/2025. The fees on the petitioner's bank account was removed and there was a specific direction by the learned arbitrator. That the state branch manager of the State Bank of India should remove the attachment put to the bank account of the petitioner. In spite of that, various representations have been issued. In spite of the said order, and also upon submission of various representations, the respondents have not unfrozen the petitioner's bank account. For which the petitioner is compelled to approach this court. The respondent numbers 1 to 4 is 1 to 4, and more particularly the respondent number 3 and 4 are directed to apprise this court as to why even after the order dated 30/7/2025 passed by the learned arbitrator, the respondents are continuing, the respondents in the State Bank of India are still continuing continuing the freeze upon the petitioner's bank account. I will give you one thing. You put the stay upon respond number 3 and 3. The stay on respond number 3 and 4. I'm saying. It is observed that pending the next date, it shall not be a bar on the part of the State Bank of India, the respond number 3 and 4, to unfreeze the petitioner's bank. Mr. Datta, I've thought about it. I do one thing, direct the registry to re-register this case and let it go before the bench, appropriate bench tomorrow. This court has duly taken note of that the instant repetition, the instant application has been filed under Article 2 to 7 of the Constitution. And under such circumstances, the application should have been registered as a civil revision, CRPIO. Instead, it has been registered as a writ petition. Considering the above, this court directs the registry to re-register the instant application and thereupon list the instant application before the appropriate court tomorrow.
Is your motion? Filed our affidavit this morning.
Fine. Ms. P. Chakraborty, the learned counsel appearing on behalf of the respondent number 1 submits that the affidavit has been filed today in the morning. The registry shall list this matter immediately on list the matter on 29th of July 2026. The said affidavit be brought on record. Liberty given to the petitioner to file reply. It's so advised. Yes, what is this?
Matter relates to, my lord, holding of the first meeting, my lord, after the election of the Gaon Panchayat members. Our claim is this, my lord, as per Rule 46, the written notice has to be served upon all the members, my lord. In an instant case, without the serving the notice upon the petitioners, the first meeting is held.
Anyway, some affidavit has been filed. No?
Today, my lord, private number 6 has filed the affidavit. Number 5.
Today they have filed.
Today morning, my lord.
You are filing. Okay, and then okay, you Mr. Mohanto, you are paying for respondent number 6.
5.
Who will pay for 6?
My lord, 6 the service is complete, my lord, nobody is.
6 is Okay.
The Vice President.
The Vice
The
President of
service is complete. And an urgency is expressed by Mr. R.M. Decca in the matter. Considering the above, list this matter on 24th of July 2026. Liberty granted to the parties to complete the pleadings on or before 22nd of July 2026.
developed.
It's for admission. Huh? What is this?
Yes, they have filed an affidavit also.
What is this I?
Lordship, the IA was for a recovery of the amount that is already paid to the respondent number 4, despite there being a writ petition pending, Your Lordship, specifically praying not to make the full compensation payment to the respondent number 4. In light that petitioners were excluded from the Zirat compensation, Your Lordship. But we have just received the affidavit in opposition, Your Lordship, today, Your Lordship.
The state respondents have filed the affidavit in opposition. List this matter again on 29th of July 2026. In the meantime, the petitioner will be at liberty to file the reply. List the matter on so and so for admission. On which date an attention and so and so. On 29th of July, petitioner would be at liberty to file the reply on or before 27th of July 2026. An attempt shall be made to dispose of the petition on the list.
Obliged.
Service being complete, list the matter for admission. Service is complete. Service being complete, list the matter for admission on 30/7/2026. Liberty given to the parties to bring on record their pleadings on or before 28th of July 2026. What is this?
My lord, item number 15 is a writ petition, my lord, where I am seeking release of my salary. And the interim prayer is to release at least the current salary. I have been out of salary for the last 1 year.
That matter. What is happening?
Approximately for the period of last 1 year, my lord, I have
The other writ petition is here, na?
other writ petition. Your side is there.
You go, you are respondent, na? Okay, no problem. Now, first of all, he has to get the money. It is what has happened in UNN. UNN directly informed that Gauhati has already issued letters to respondent to take the necessary action. So I think this will be allowed. Take action for release of the salary to so and so, so and so. So there is already a direction being issued for release. Anyways, the other, we need to finish up the other matter.
That, my lord, that, my lord.
No, that the problem is because of the other matter. In fact, your petition now has become infructuous in view of this. You will be getting your salary. But because of your petition, I think the other matter also needs to be finished.
Well, that can be done, my lord, but what I am on, my lord, unless and until, my lord, the respondent number 9. Respondent number 9 releases my name from the FIN Assam. My salary is not being drawn
They
here.
have already issued letters to respond number 7 and 8. Register so-and-so level this year has already issued letters to 7 and 8 to take necessary action for release of the salary in respect to so-and-so. Annexure 1, it has been issued by the Joint Secretary to the Government of Assam. Consequent upon the Gauhati High Court's direction in respect to so-and-so, I am directed to request you to release the salary in respect of so-and-so. The presiding officer direction has already gone.
Previously also, my lord, the such directions were given, but he is not complying. That is the problem.
Regarding release of the salary in respect of so-and-so, this is another department. This is given on 16/5. so and so I'm directed here, but have taken over charge as the registered labor court. But till date, so and so could not draw his salary from here. The presiding officer, while under reference, has been informed that due to non-transfer of the name from Green Assam by so and so, salary bill could not be processed. As such, we are requested to do the needful. Now, who has kept it in the Green Assam?
Well, that is respondent number 8.
Huh?
Respondent number 8.
Who is he?
Well, the presiding officer of the tribunal.
Transfer of the name of. We do one thing. Now, where are you?
I am, my lord, at Gauhati.
Where? Where's the other one? You are where? None appears. Where is he?
She is nowhere, my lord. She was supposed to go there.
He
my
or
lord.
she?
She.
What happens, my lord?
She was supposed to go at Dibrugarh, my lord. She has not joined there. And she is neither at Gauhati.
What happened? The order, the beginning of the thing is that in the Green Assam portal, the detail has to be changed from Industrial Tribunal Dibrugarh to Gauhati. In the subsequent information, there is an order passed not to take course of action. Apparently, the transfer order which is passed subsequently is the same with the earlier transfer order. Is Miller in violation of the Honorable Single Judge's previous order? No, anyway,
So,
no, you see, the thing is this, now this order I'm going to modify now. 1/4/2026, I'm going to modify. I'll make it very clear. Either I will stay it or whatever it may be. This, because of this order, it has all happened. Because it is an,
second repetition,
with due respect, it is an ambiguous order. How can there be no coercive action? Means either they have to go, they may not have to
Because
go.
the-
Either you have to stay, don't stay. What do you mean?
impugn order in the second repetition is in clear violation of the previous order passed by the Honorable Single Judge. That is apparent on the face of the record. In view of that, this impugn order should have been stayed with all due respect.
Now, if it is state, then what happens?
If it states.
Where does the petitioner go?
He'll have to go back to Dibrugarh. If he has joined for any reason, taking release from Dibrugarh, since the order has been stayed, he'll have to go back to Dibrugarh till outcome of the.
I have joined here last year, 21st July. Sorry. On 7th of July. From 7th of July, I am here, my lord. There are orders accepting my joining at Gauhati. And because of the fight created by this lady, my lord, the respondent number 10, my lord, now I am at the receiving end. Neither I am getting my salary from here nor from there. My only concern is that wherever you may choose me to be, at least give my salary. Last 11 months, my lord, I have been running without salary. How can I survive? Next 2-3 months, my lord, I am going to retire.
Mr. Das, tell me one thing. Yes, the order which was being passed from one place to the other was stayed, was set aside. Whereby she was sent
To Dibrugarh.
to Dibrugarh and he was sent to
brought
Gauhati. That was set aside. Now thereupon, which means he goes to Dibrugarh, she comes to Gauhati.
Yes.
That is there.
Yes.
Appeal filed there against, appeal is pending.
No, appeal has been now it is being disposed of.
When?
Infructuous.
Has been disposed of.
Because of the second writ petition, the appeal was initially, my lord, in the appeal, in the first order, it was observed that it will be heard on merit. When the impugn order in the second writ petition came, again reiterating the first transfer, my lord,
No,
I'm sorry.
Now the appeal has been filed. At the time of the appeal, the court did not stay the single judge's judgment. But the court says that we'll decide on merits.
Correct.
But in the meantime, there is a requirement of passing again an order.
Fresh order.
Fresh order. And in pursuance to that, they repeat the same order which was set aside.
Exactly.
And therefore, the second writ petition.
Second writ petition.
And because of that, passing the same order, if there is no justification is being shown.
Yeah.
If there is no justification is being shown, then in that regard, the problem arises out there is the same order is being repeated.
Same order.
So the court has passed an order not to take coercive action. The court should have passed the order of stay. Let me be clear, there should be a stay. So therefore, once I stay this order, the petitioner shall draw I can pass consequential directions in the other petition, thereby directing the person in Dibrugarh to put his name in Finasan there and give him the salary.
His name is already there in Finasan Dibrugarh.
So he'll get the salary from there.
Now, will it be staying? Why did the court not pass an order of stay? Is because of the fact that from 21st of from 7th of July 2025, I'm already here. And before the division bench, Milord, this lady respondent number 10, she made a statement on affidavit that she had already proceeded to go and join at Dibrugarh. Your Lordship will kindly see page 80 of my affidavit. That was a statement made before the court. 80. Yes, page 80, para 9.
Huh?
This was
18.
80. My lord, I have filed an affidavit in the matter.
No,
In,
no.
in item number
80 is different. This is some by presiding officer in your retribution.
in 1507, my lord, I have filed an affidavit.
1507. No.
Yes.
Why you are going to 1507? Anyway, what is that?
My lord,
80.
page 80.
Yes.
In the IA filed before the honorable division bench, my lord, this was the statement made that she had already proceeded.
Where? Paragraph?
Para 9.
In that due deference of the impugned transfer order, the applicant without her prejudice as exposed in the instrument have proceeded to join the industrial tribunal Dibrugarh as the presiding officer.
It ought to have been
As
raised.
the presiding officer?
It ought to have been raised, my lord. Maybe it's a typographical error. The same word has been repeated. So considering this, my lord, the stay order was not granted.
We do one thing then. We remove that order. Yes. You have joined there.
He was already there, he was not relieved from the.
No, my lord, that is
No,
not correct.
I'll show my, if your worship kindly comes to
Let
my
me come back at 2. Who is appearing to the Labor Department? Why they are not here? Yes, who appears for the Liberty Park? Why have you transferred him? Mr. Setia, let me tell you. Earlier, when the transfer was made, it was made at the request of Mr. S. Doctor's client. That is a finding arrived at. And as such, the learned single judge categorically held that the transfer was not in public interest. That judgment was not interfered by the division bench. That aspect is clear. Now, what was the reason for which you have again made the same transfer? Now, if you see the reason given at page 45 of the writ petition which have been filed by Mr. Chaudhary's client, is it is in compliance to the order passed by this court. So this transfer order has to be set aside. Once it is set aside, the matter is resolved.
But in this transfer order, it is mentioned it is done in the public interest.
No, you cannot make just public service in the interest of public service unless you have, the moment you are asking for, saying that you are complying with that earlier order, then the public service, in the interest of public service, which you are mentioning out there, does not have any further color there. It is just your use of the words, I will put it the word as superfluous to make it more colorful, the transfer order. It is in violation of the court's order. We set aside this notification. Then everyone goes to everyone's place.
Well, so far as this order is concerned, the government is yet to file any affidavit.
Not
in the
that
matter.
they had the chance of filing it. They have not filed it.
Yes.
And because of them, this situation has arisen. If they take a proper decision, that is their lookout. If they take a proper decision, let them take a proper decision. They should be more active for the purpose of filing the affidavit. On one hand, they say to be in compliance to the judgment passed by the learned coordinate bench. And what did the division bench say? The division bench only said that in view of this, let there be an order being passed. Now, this is what only to the effect the division bench thereupon held that the appeal has become infructuous because of the filing of that order. But be that as it may, the question remains out here that when you are putting the word that it is in compliance to the judgment you are doing it, you cannot say, the Labor Department cannot say that in compliance to the order where it has been set aside, you are again passing the same order.
No, that they are qualifying it by the order passed in the writ appellate court.
Writ appellate court maybe, but the writ appellate court, what has happened there thereafter? There has been held to be infructuous.
No, it was held infructuous after passing of this order, not
Maybe.
before that. The
Maybe
writ
it
of-
has been passed in that regard, but the writ petition, the writ which was issued by the learned single judge, has not been touched by the division bench.
No, that has not been touched because of the fact that already a fresh order has been
You
issued.
can very well go to the division bench. I'm setting aside this order. Once I set aside, and there you will get your salary wherever it is. But Mr. Chaudhary, you are the main man. Personal. Heard Mr. M.K. Chaudhary, the learned senior counsel. Assisted by Mr. M. Sharma, appearing on behalf of the writ petitioner in WPC number 1507/2026. And Mr. S. Datta, the learned senior counsel, assisted by so-and-so who appears on behalf of the respondent number 5. Mr. M. Setia appears on behalf of the Labor Department of the Government of Assam. It is also relevant to take note of that the respondent number 5 in WPC number 1507/2026 had filed another writ petition. Had filed a writ petition being WPC number 2742/2026, wherein Mr. M.K. Chaudhary, the learned senior counsel, assisted by so-and-so, represents the respondent number 10. I've also heard Mr. H.K. Das, the learned standing counsel, senior counsel, as well as the standing counsel of the Gauhati High Court. For the sake of convenience, this court would refer to the parties as have been arrayed in WPC number 1507/2026. The writ petition being WPC number 1507/2026 have been filed by the petitioner, being agreed that the order notification dated 11/3/2026, whereby the writ petitioner was transferred from the post of Register Labour Code Gauhati to the Register Industrial Tribunal Dibrugarh, and the respondent number 5 was transferred from the post of Register Industrial Tribunal Dibrugarh to the post of Register Labour Code Gauhati. For the sake of convenience, the said notification, impugned notification, has relevance for which the contents of the said notification is reproduced hereunder. Page 45 of the state. A perusal of the above quoted notification would show that the said notification was issued in compliance to the judgment order dated 2/12/2025, passed in WPC number 3585/2025, read with the division bench order dated 18/12/2025 in writ appeal number 409/2025, and further uses the expression, inverted comma, in the interest of public service. It is under such circumstances necessary for detailing out the facts which led to the passing of the order dated 2/12/2025 in WPC number 3585/2025, as well as the order passed by the learned division bench of this court dated 18/12/2025 in writ appeal number 409/2025. The records reveal, and more particularly, the order dated 2/12/2025 passed in WBC number 3585/2025 reveals that the respondent number 5 herein had submitted a representation expressing personal hardship relating to his ailing mother and child, and therefore sought for transfer to Gauhati. The said representations were submitted by the respondent number 5 was examined in detail by the authorities and was approved on 6/6/2025 at 8:04 p.m. by the Additional Chief Secretary. Subsequent thereto, the concerned minister of the department granted the approval on 13/6/2025 by putting his digital signature at 6:03 p.m. Thereupon, the transfer order was passed on 26/2025. The said transfer order dated 26/2025 was challenged by the petitioner herein on the ground that the said transfer order was not in the interest of public service. The learned coordinate bench of this court, by the order dated 2/12/2025, was challenged in WPC number 3585/2025. The learned coordinate bench of this court, by the order dated 2/12/2025, not only took into account the respective pleadings, but also took into account the records which were placed before the learned coordinate bench. This aspect could be seen from a reading of paragraph number 10, 11, 12 of the order dated 2/12/2025, which is reproduced here in under. The learned coordinate bench further, taking into account the settled principles of law, came to a categorical finding that the transfer order dated 26/2025 is a case coming within the ambit of that the impugned transfer order was not issued in public interest. This aspect could be seen from paragraph number 20 and paragraph number 21 of the order dated 2/12/2025, which is reproduced hereunder. On the basis of the above conclusions, the learned coordinate bench of this court interfered with the transfer order and directed the respondent authorities to pass consequential orders for tweet. This direction for passing consequential orders forthwith is relevant when this court would be taking up the directions which have been passed by the learned division bench of this court in the order dated 18/12/2025. The records reveal that being aggrieved, the respondent number 5 preferred a writ appeal against the judge order dated 2/12/2025. The said writ appeal was registered and numbered as WA number 409/2025. The learned division bench of this court categorically observed that by the impugned judgment, that is the order dated 2/12/2025, a fresh order of transfer was required to be passed accommodating both the appellant bracket, the respondent number 5 herein, and the respondent number 1 bracket, the petitioner herein. And as such, directed that such an order be passed notwithstanding the pendency of the appeal. It is surprising to take note of. Now, in the above context, let this court now analyze the notification dated 11/3/2026. The transfer order dated 26/2025 was interfered by the learned coordinate bench of this court by the order dated 2/12/2025. While interfering with the said order, transfer order dated 26/2025, the learned coordinate bench further made it clear that there will be a necessity of passing a consequential directions, which meant that specific posting has now to be issued. In view of the interference with the transfer order dated 26/2025. The learned division bench of this court did not interfere with this, neither did stay the directions so passed in the order dated 2/12/2025. Rather, made it explicitly clear that there, as the learned coordinate bench of this court had directed for passing of consequential order, such order be passed irrespective of the pendency of the appeal. In the above context, if this court now takes note of the notification dated 11/3/2026, which is impugned in the instant proceedings, it is surprising and shocking to take note of. The Principal Secretary to the Government of Assam Labour Welfare Department failed to understand the basic wordings which have been used in the orders dated 2/12/2025, as well as the directions passed by the learned coordinate bench, a learned division bench dated 11/18/12/2025. It is mentioned in the impugned notification that it is in compliance to the directions passed by the learned coordinate bench dated in the order dated 2/12/2025, as well as the learned division bench dated 18/12/2025. But on the other hand, again reiterates the transfer order dated 26/2025. They said, in the opinion of this court, not only is it contrary to the directions passed to the order dated 2/12/2025, as well as the order passed by the learned division bench dated 18/12/2025, but it goes against the very concept of rule of law. The directions which were passed as by the learned coordinate bench as well as the learned division bench were clear, explicitly clear. And the order which has been impugn notification which had been passed by the principal secretary to the government of Assam Labour Welfare Department is on the face of it contrary to the said directions. Consequently, it is therefore the opinion of this court that the impugn notification dated 11/3/2026 cannot be permitted to be sustained in law. Accordingly, the instant writ petition stands disposed of with the following observations and directions. The impugn notification dated 11/3/2026 is contrary to the directions passed by the learned coordinate bench of this court dated 2/12/2025, passed in WPC number 3585/2025, as well as the order passed by the learned division bench dated 18/12/2025 in writ appeal number 409/2025, and as such, the same is set aside and quashed. Full stop. Taking into account that under this court further declares by the this court further observes and declares that the petitioner herein, that is Polikuch, would be deemed to be posted as the register of the Industrial Tribunal Dibrugarh, as the registered Labour Court Gauhati, and the respondent number 5 shall be deemed to be posted as registered Industrial Tribunal Dibrugarh. In view of setting aside and quashing the notification dated 11/3/2026. Number 3. It is, however, observed that a quashing of the notification dated 11/3/2026 shall not preclude the respondent authorities to transfer the petitioner or the respondent number 5 if it is necessary in the interest of public service in future. The above directions, in view of in the backdrop of the above, let this court now take up the second writ petition. Second from Belikid branch. Now the instant writ petition has been filed by the petitioner herein, who is aggrieved by the non-release, which is agreed by the actions on the part of the respondent respondent number 8 in not transfer oblique release of his name in PIN-Assam portal from the Industrial Tribunal Dibrugarh to the Labour Court Gauhati. Next. This court, by the separate judgment and order, had set aside the notification dated 11/3/2026, whereby the petitioner herein, whereby the posting of the transfer of the petitioner herein from Registered Industrial Tribunal Dibrugarh to Registered Labour Court Gauhati have been interfered with. Under such circumstances, the directions which have been sought for by the petitioner herein to the respondent number 8 to immediately transfer oblique release the name of the petitioner in the PIN-Assam portal from Industrial Tribunal to the Labour Court Gauhati cannot be passed. Be that as it may, this court duly take note of that the petitioner herein have been rendering his service and as such would be entitled to entitled to his salary. The respondents herein that is the respondent number. No, not you. You have no business here. We direct the respondent number 2, 3, 4, and 8. Respondent hearing, and more particularly the respondent number 2, 3, 4, and 8. No, 1, 2, 3, 4, and 8 are required to take immediate steps for release of the petitioner's salary as per his entitlement. As the register of the Industrial Tribunal Dibrugarh, the said exercise be completed within a period of 15 days from the date 15 days from the date from the receipt of the certified copy by the respondent number 8. Huh? Means, are you saying that 10 respondents he is going to serve certified copy?
8, man.
How many? 1.
1, 2, 4.
He has not got a salary, and now you want 4 certified copies to be given to so many people.
He is practically a non-party now. His appearance is only with regard to the correspondence that was made with the ICO. So it should go before the respondent number 8. Only thing is that if your lordship specifies the period, because it will be from last
Say
July.
15 days.
No. The duration of salary will be from last July. Because I am out of salary since last July.
No, you have not come before this, right? Why should I pass? No, his entitlements, I said, no. Why should I specify?
No,
this
but
fact?
because other, since in between he came and joined here, my lord, then it may give rise to complication.
No, I said, well, I said that you'll be deemed to be in service in as industrial tribunal, Dibrugarh.
Yes.
That is what, and his entitlement will be this. So I interfered with this. So therefore, you will be entitled. Now the question is serving the certified copy upon whom?
Well, it should go before, I'll submit before respondent number 1, 2, 4, and 8.
Now, why do you do? Don't bring four. Four is a very dangerous thing. You don't bring four. Four will create problems. We said directing the response number.
Then,
You give
then
it to two.
2, 3 and 8. 2, 3 and 8.
2, 3, and 8. Full stop. This goes further directs that upon requisition being made, that any that 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 this goes further directs that upon steps being taken by the respondent number 2, 3, and 8 for release of the petitioner's salary, the respondent number 4 shall do the needful. But Mr. Das, I have serious doubts as to how these transfers are being happening after my death judgment by these departments without the concurrence of the High Court. Because that is not possible because of the fact I categorically held that he comes within the ambit of the subordinate judiciary.
Correct.
If I hold it to be subordinate judiciary without taking the concurrence of under the High Court under
Cannot be-
235, how is it?
Cannot be made, madam. After your lordship's judgment, it cannot be done, madam. On that count also, this
I
order,
put one line there. In that line out there where I have given the liberty, but
Correct.
that will be subject to the observations made in the other judgment.
yes, madam, that will help, madam. And government will also be aware that this judgment
Because
is
the
there.
government on its own cannot. That is the having
They have to have the concurrence of the Gauhati High. They have to intimate and have
I think-
communication.
it with a judgment that's
Dilip Kumar Devo Sharma.
Deva Verma. What is
Devo Sharma, Dilip Kumar Devo Sharma.
Dilip Kumar Deva.
Well, I'll give the number.
You give the number, the
Yes.
judgment date and
Yes,
number.
yes, madam. I'll give.
Then they will have to process it through the High.
Yes, madam. Yes. WBC number 7066 oblique 2024. Well, I'll give the number.
What is this? Oh, yes. What is this order you have got? You are the writ petitioner. You come this way. You go that way. Now, you have challenged some notifications in your petition. You have challenged these addendums with some orders. You have challenged an order dated 14/8/2025. Kindly come to 96. In and peruse the letter dated so and so. Requested the rectification of the report wherein on online. As per the online Jamabandi, name of AI is found in speaking of condition from the land of so and so. So and so, so and so. Whereas in perusal of the order detailed using the requisition is not concerned with the civil land. Whereas on perusal of paragraph 4 of the order dated so and so, it is seen that the Honorable High Court is of the opinion that the judgment detail could not be relevant for the aforementioned land. Therefore, in view of the above, the circular of is hereby directed to reinstate the name of NFL. Okay? Now, if this land is there, you are challenging this. Has this land been set aside? No. There's an addendum there, which has to be, you are asking for setting aside. Now, why you are raising construction?
No, my lord, there is a status quo order in this case.
No, no, understood.
Already,
Status
my
quo
lord,
means what?
before, my lord, before this petition, my lord, another petition was filed between these two parties. This honorable court directed for demarcation. So already demarcated. And that demarcation, my lord, it is come out, it is in my position. And it is mine.
Everything
Yes.
understood, but as of now,
No, my lord, there is a construction is already there before this order.
very well. No further construction.
No. My lord, now there is no construction.
No, you would not carry out any.
No,
further
my lord, no. And my lord, already another
I
contempt,
make it very clear.
my lord,
You say that the construction has already happened prior to this order passed impugned in the instant proceeding.
yes, my lord.
And there is an undertaking not to carry out, and this court directs no construction till disposal of till the next.
My lord.
The status quo will mean status quo as regards possession. If you are in possession, you will be when title, construction, or as well as not to change the nature and character of the land till the next.
My lord, my lord. Already, when this earlier petition was not going on, there, this construction was there and there is.
So very well.
My
There's no problem of that.
That building was already there and there was a construction of that is
Okay.
there.
I understand. So no further construction.
Man, no,
Because this has happened.
yes,
Then I will close down the contract. Contempt is unnecessary.
One more thing, Lord, same Lord, that after filing of our contempt, they have also filed a contempt. Now, what has happened, my Lord, consequent.
We'll see when that matter.
No, my
That
Lord,
matter has
now
not-
what the circle officer has deleted the name of the railways from the Jamabandi, my Lord, thereby altering its own order.
No, that is another aspect
Mm.
which we'll look into it by filing another writ petition. You can very well file writ petition. You file it. Let us be one by one. You see, the order which was passed earlier, with due respect, that order was a bit vague, which makes it very difficult for both parties to understand.
But in the background circumstances, Lord,
Understood. My question is, he says
was-
that he has already constructed prior to the order impugned, that is 14/8/2025. He says, there shall be no further construction. That's all. No. Heard Mr. So-and-so, the main petitioner, heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, and Mr. H. Gupta, the learned CGC, who appears on behalf of the NF Railway. Who appears on behalf of the respondent numbers 1, 2, 1 and 2. He appears for respondent number 4, 5, and 6. Ms. P.R. Mohanto appears for respondent number 3. Who is 7? Mr. Counsel?
my lord, 7 is the, my lord, to whom, my lord, I have already, my lord. I am
Your,
owner of the
your
construction,
person.
construction company.
Your person.
Yes.
Now, he's your person.
Yes.
So you will be bound.
My lord,
Ask him not to construct.
my lord. My lord, now as per my, today I have already taken instruction that there is nothing.
The instant writ petition has been filed by the petitioner. Challenging the order dated. (14/8, 2025). The addendum dated 14/8, 2025 and the corrigendum dated 27/8, 2025. All issued by the respondent number 4. A perusal of the order dated
Seventeen.
14/8, 2025 reveals that the circle officer, Gauhati, Revenue Circle was directed to reinstate the name of NF Railway Gauhati for the plot of land measuring 3.08 R covered under Dag number 317 of KP Patra number 419 of village Gotanagar under Jalukburi Moja. In pursuance thereto, an addendum was issued on 14/8/2025 and was followed by a corrigendum dated 27/8/2025 by the respondent number 4. It is the specific case of the petitioner that the said orders impugned in the instant proceedings is contrary to the records inasmuch as during the field verification it was observed inasmuch as at the time of carrying out an earlier demarcation, isn't it, Mr. Counsel?
Yes, my lord. My lord, order dated 26/12/2024, page 71. my lord.
Inasmuch as in the order dated 26/12/2024 passed by the respondent number 4, does the order say?
No specific finding. That is
No specific finding.
Yes, my lord, this order, my lord, by this addendum, my lord, they corrected this order. My lord, by this order, my lord, nowhere said that my lane is, my lord, come under railway state. So, my lord, this
No,
order
whereby the respondent number 4 by the order dated 26/12/2024 had directed both the parties to approach the competent court of civil jurisdiction. The learned counsel appearing on behalf of the petitioner submitted that when the respondent number 4 had directed the parties to approach the competent court of civil jurisdiction, the respondent number 4 could not have exercised its jurisdiction by passing the order dated 14/8/2025, as well as the consequential addendum and the corrigendum. This aspect needs to be deliberated upon when the respondents bring on record their stand by filing the affidavit. However, it is noticed that however, during the course of the argument, Mr. H. Gupta, the learned counsel appearing on behalf of the learned CGC, submitted that after obtaining a status quo order from this court by the petitioner, they are raising construction over the land in question. The learned counsel appearing on behalf of the petitioner submits that all constructions which were carried out by the petitioner as well as the respondent number 7 were carried out prior to the order passed on 14/8/2025. He therefore submits that there is no violation to the order passed in the order dated 17/10/2025. Having heard the learned counsels, it is the opinion of this court that the said order dated 17/10/2025 has to be made more specific, inasmuch as merely observing status quo over the suit land, over the land, would lead to further complications. Accordingly, this court therefore directs that both the parties to the instant proceedings shall maintain status quo as regards possession, title, construction, as well as not to carry out, as well as not to take any further steps in respect to which would change the nature and character of the land which is the subject matter of the order dated, impugned order dated 14/8/2025 till the next day. List this matter. Mr. Gupta, the learned counsel, learned CGC submits that the affidavit will be filed by okay, yeah, Gupta Gusari. Okay, when you are filing it? Means that the affidavit could be filed on or before 17th of July 2026. List this matter again on 27th of July 2026, 29th of July 2026. Liberty given to the petitioner to file reply on or before 28th of July 2026. List the matter on 29th, huh? 29, liberty given to file the. It is further observed that the interim order passed herein above shall continue till the next stage.
Obligement.
Because of the contempt is heard Mr. So-and-so, the learned counsel appearing on behalf of the applicant. The learned counsel submits that in view of the order passed in the petition, the petition number so-and-so today, that is the applicants would not like to insist on the pursue the instant application. Accordingly, the instant application stands closed as notice. Purpose served for both of you. In 17. Yes. And appeared on behalf of the parties. None appears on behalf of the petitioner on call. For the end of justice, this court adjourns the matter again to 15th of July 2026. It is observed that if on the next day the petitioner is not represented, this court shall construe that the petitioner no longer is interested in the present proceedings. Mr. Parvez, today I was looking for you in the other matter. There was one repetition file as regards some state bank matter. In fact, that was a small thing which could have been finished up. There was an arbitrator's order to, on the basis of an arbitrator order, the state bank frees his account.
Yes, sir.
Thereupon, the arbitrator passed an order to defreeze it. Now you are not defreezing from
My
2020.
lord, whether that order was communicated to the bank, that has to be seen.
That is the only thing, it was a very simple thing. It could have
Simple,
been changed. I was looking for you, Mr. Kumar. Anyway, now tell me what it is.
My lord, in this case, acquisition compensation has been received, but the acquisition compensation is not paid till date.
What did you get? Acquisition compensation? You got
It is received, my lord.
Have they looked into the aspect as regards acquisition, requisition?
The
compensation?
acquisition they have admitted in their reply affidavit. The acquisition compensation as per the authority is rupees 7,68,553. Affidavit in opposition filed by the respondent number 4.
Then why haven't they paid it?
No, they have not paid it.
Okay, I have issued notice in this matter. No? Why are you not paying it? The affidavit reply has been filed by them. Affidavit in opposition filed by. Where, at which paragraph?
In paragraph 6.
Hmm?
Paragraph 7, page 107.
What one do you say? Who's affidavit?
Affidavit filed by Kamal Borua.
Who is to make the payment? Huh? No. Yes. Yeah, this is for acquisition. Acquisition, he has got it. It's only the
Yes, they
requisition
have-
amount.
Requisition is not paid.
Huh?
Yes, requisition is not paid.
Only the requisition amount. Here you see, kindly see page 107, 7,68,000.
The lordship did contain.
Heard Mr. Pervez, the learned counsel appearing on behalf of the petitioner. Mr. S.S. Roy appears on behalf of the district administration. Mr. B. Gogoi appears on behalf of the respondent number 5. The petitioner, the Mr. Pervez, the learned counsel appearing on behalf of the petitioner submits that the petitioner have already received the acquisition compensation. However, despite the admission on the part of the respondent authority that the petitioner is entitled to an amount of 7,68,543 towards the requisition compensation in terms of section 11(4) of the Assam Land Requisition and Acquisition Act 1964. The respondents have not made the payment. It is also seen from the affidavit filed by the respondent number 4 that the said amount is duly admitted. Mr. B. Gogoi, the learned standing counsel of the PWD department, submits that he would obtain instruction as to when the said amount would be paid to the petitioner. list this matter again on 5th of August 2026. In the meantime, the respondent authorities, Mr. B. Gogoi shall obtain instruction as to when the payment of rupees 7,68,543.10 paisa would be paid to the petitioner. Pending the next date, it shall not be a bar on the part of the respondent authorities to make the payment to the petitioner. Well, look at that. Now we finish. Mr. K. Gogoi, after during the lunchtime, I thought the best order would have been in that case is let the acquisition go on, but acquisition should be done with consultation with the revenue staff. That would have finished it. Because their basic case was only that this is my land. So revenue will be thinking matter over. Later on, my brains it came to my mind. This is the best order which was anyways. Yes, pleadings are complete.
Lordship, the order that has been violated, my lord, will find at
What?
page.
Contempt?
Yes, my lord. At page.
What
15
contempt?
At page 15, your lordship will find the order.
What is the order?
My lord, I am the tea garden owner of a very old garden at Vigivar, my lord. From page 16
In
onwards.
the next day, demand notice dated so and so shall not be enforced without the leave of the court.
Yes, my lord.
Then what happened?
Then what happened, my lord, that you should may kindly see, the display at paragraph 3, page 17, paragraph 3. Learned counsel for the petitioner submits that a communication dated so and so was issued by the respondents putting the petition. Page 17, para 3.
So which order you are saying the violated?
My lord, the portion that has been violated also will find at para 6, my lord. Para 6. Para
Of
6,
which
page 18.
order, Mr. Counsel?
Annexure A,
Page?
page 15.
Okay. Only the order.
Yes.
Meanwhile, in the event the department proceeds in the matter
In respect
in
of the
respect to the
notice of
notice
demand.
of demand issued here, no final order shall be passed without
Yes,
the
my
leave.
lord.
Then
My lord, paragraph 3, the previous page you also will find. The learned counsel for the petitioner submits that a communication dated so and so was issued by the respondent, putting the petitioners to notice that he has failed to pay the monthly wages and.
then what has happened?
The disputed amount is 22 lakhs, my lord, with regard to payment of notice of 1 crore 12 lakh. That what happened without settling this issue, my lord, and in violation of this order, page 32, my lord, you will find, they have attached my whole property. The property, the land is measuring 1569 bighas, my lord. And they have, page 32 is the order, my lord, order of attachments. For 1 crore 12 lakhs, they have attached my whole property, my lord.
But this attachment happened on 26/2024.
Yes,
And your order was passed on 25/11/2024. How does it have relevance?
No, my lord, 25/11 it was passed.
What? That is the order. 25/11/2024 is the order you are saying, which is at page 16. And the attachment happened on 26/2024.
Yes,
How is it
sir,
relevant?
during the pendency of the litigation.
How? That is not a contempt.
Yes,
No,
my
it's
lord,
not a
because
contempt.
they have attached the whole my land.
Understood. My
see,
question is, if you are saying that page 31 happened after the year, that is not possible. Because this order is dated 26/2024, whereas your order, which you are referring to, is 25/11/2024.
The order of attachment, my lord, page 32.
Page
32.
What is the date?
Date is
31st December
31st December.
specification.
Yes, my lord.
Order of attachment of immovable property management
That is
and so
notice
and
of
so.
demand, my lord.
This is on 31/12/2024.
Yes, my lord.
So here it says, in the meantime, in the matter of notice of demand dated 19/12/11/2024, which is, so thereafter the order of attachment was passed.
Yes, correct. The whole land they have attached, my lord, And without intimating me, their only stand is that this is not a final order and that they have given the Zimmer to, I am running the garden. But fact of the matter is that Lordship may kindly see, what I am saying is that connected with petition that give me 3 months time. You take back your attachment order and I'll pay the amount demanded by you. Even without settling the disputed amount.
what is it?
Lordship, we have not even gone ahead for selling of the garden. He is only running it. No,
If we
incorrect.
proceed further, then definitely we would have taken leave of this court because we are not, he is running it, we are just in. If a lordship
Lordship,
see
may
the
kindly see the affidavit there.
we are just
My lord.
restricting him for transferring or charging the property for our security.
My lord, without my authority giving attachment to a third person, my lord may kindly come to page 85 of their affidavit.
You're giving it to somebody else?
No,
Yes,
no,
my lord,
he is
without my authority, somebody else. Yes, my lord, all vested interest groups are coming around.
Panchnama.
My lord, my page 85, Panchanama. Here, my lord, will find on reaching the aforesaid premise, the officers met street, nobody, blank. What is this? My lord, details of attachment, they are not giving the details of attachment of the land because they have attached the whole land unproportionately. For 1 crore, even that disputed 22 lakhs is there, they're attaching my whole 1569 bighas of land.
Lordship may see the.
My lord, they
next
have
page.
made my high blood
Robin
pressure
Gogoi,
high.
The head clerk is, we have given the punch number.
Absolutely false, my lord.
Next
Lordship,
is 85.
I'll give this.
Robin Gogoi, the head clerk, we have been giving. the-
So let them
He has
show
taken the
authority,
punch number,
let them show
Robin
the
Gogoi.
authorization.
85. It is in presence of his employees and he is running the.
Well, absolutely no authority. We are taking in confidence of that Mr. Gogoi and doing all kinds of illegalities. And next page also see, Lordship may kindly
Lordship may
see,
kindly see
page 86,
65.
my lord, page 86, my lord. Next page. The attachment started at 11 hours and concluded at so and so. The officers, after conclusion of the attachment, offered themselves for personal search, which was declined by the party. The officers have taken into possession nothing and have handed Jima of all the goods, documents, to whom my lord not stated, my lord. And I have inquired my client, my lord. He has stated that I have given no authorization to Mr. Robin Gogoi. I have given the letter, my lord. This is- Absolutely, my lord, whole they are up to grabbing my whole 1569 bighas of land. They have not settled the 22 lakhs money. And defying court's order, my lord, they are doing all this.
But why did you
Yes.
not seek the leave of the court before attachment?
That day, Mr. Justice Soike was
Lordship,
very angry on them.
Lordship, the direction was that we can proceed. However, the final step should not be taken. That's all I understand. We are not even going ahead with the sale, auction, nor appointing third parties receipt.
But why did you go for attachment?
Attachment is only the.
What has happened to the writ petition?
Writ petition is pending. Only
Well,
attachment is.
In
only
the
for the purpose
repetition,
that-
I have given an undertaking that he remove the attachment. In 3 months, I'll sell out the proportion of land and give you the whatever is this due to you, and please remove that. That also he is not doing.
We do want to have this matter with the other writ petition.
My lord may kindly drop contempt. They have apparently disobeyed the.
No, we do it with this and that. Because you see, I can't pass certain consequential directions here. I can only hold them in contempt, but this is not going to help you.
Yes, yes.
You need the garden back.
Yes, I am.
So I have to set aside the attachment there.
Garden is with him.
My lord,
Yes,
apparently,
we have to set aside.
Incorrect,
the attachment.
incorrect.
This is in violation to the protocol.
yes,
We set aside, thereupon we may dismiss his writ petition, that's a different aspect to them.
I have given my absolutely no authorization.
We set aside that attachment because without the leave, you could not have, attachment also implies. Did you give it to somebody else? How could you give it to somebody else? Or why didn't you hand it over to him?
Yes, my lord.
You are attaching. Well, you attaching means what? How are you attaching?
Entire 1569
The
bighas.
lordship is attaching.
Entire 1569 bighas of land. they
Your
have attached.
power of attaching is for what?
Only for that purpose, it
Proportionate
does
amount.
not transfer it to third parties or create, only for that purpose. The attachment notice itself says. We don't want to create it so that he does.
You have not therefore touched physically.
Yes, no.
It is only in words.
In words, symbolic.
This matter after vacation on 4th of August 2026, along with WPC number 6187 of 2000.
Another petition is there, my lord, along with 1539. We have challenged the their attachment order also. WPC 1539.
Oblique,
Public 25.
you forget that.
Because my lord, their atrocities made my blood pressure high, also diabetes went up. Their illegal actions at its peak, my lord.
My lord, I may be allowed to file the reply, lordship, to the affidavit in opposition, because lordship, although matter was, they have filed way back, lordship, the affidavit in opposition.
Counsel
Lordship.
appearing on behalf of the petitioner submits that he would like to file an affidavit in opposition and reply to the affidavit in opposition filed by the respondent number 9, 10, and 11. List this matter again on 19th of August 2026. The way amount they just stay, na?
This is still law.
Have it before that on 5th of August 2026. In the meantime, the reply be filed on or before 3rd of August 2026. The respondents, the state respondents, as well as the National Highway Authority of India, shall NHIDC, as well as the NHIDCL shall also file their affidavit in opposition on or before 27th of July 2026. Liberty given to the petitioner to file reply there against on or before the next.
Would like.
Yes.
My lord, here also, lordship, I have not filed any opposition yet, lordship. So, lordship, along with that matter, lordship.
Lordship matter connected
Matter
with the
connected.
earlier one. Lordship may,
Fix
this
it.
matter also may be along with the other earlier.
The instant petition is connected with, is it connected?
Yes.
Sure. Connected with other petition. Accordingly, list this matter along with the other petition about Gustav. In the meantime, the respondents are granted the liberty to bring on record their stand by filing the affidavits on or before 29th of July 2026. The petitioner shall is granted the liberty to file reply on or before 12th of August. Next, kita also. I will not. 5 to 14 go. Agoto. It took 12 to.
Like that.